Lordship, my peace Lordship. Lordship, I may be allowed to mention item 11. My senior South Station Lordship that come on Monday, Lordship. 11, Lordship.
Monday I've got a lot of matters fixed.
Tuesday, Lordship, then.
So therefore, let's try to do it today.
Lordship,
There's so many less matters, 14 matters. What am I going to do if I'm sitting at 11? People will laugh.
My senior has traveled to
Then I'll have to green all the lawyers who are going to do those matters, and it will be your responsibility. Then they will be cursing you. Because of you, the matters are adjourned. Now we have to fear the brunt of this court.
Lordship, but Lordship immigration is not Lordship. Item Monday or this day, Lordship.
At the request of Mr. Fongsa, the matter stands adjourned to be listed again on 1st of September 2025.
Lordship is an interim. Interim.
The interim order passed earlier shall continue till the next date.
Have you passed, my Lord?
No more adjournment. One is enough.
For motion, item number 1.
Oh, this one.
Yes, my Lord.
What have you thought?
Yes,
Have you looked into?
yes, my Lord.
I think you better do that. That would be more helpful. Have you seen that my judgment? I have delivered on one judgment where it is the power is much more of this court.
Yes, my Lord.
Okay? You withdraw with a liberty to file a revision under 32, na?
Yes, my Lord.
32 or what?
32, Your Lord.
32, na? Then don't trouble Mr. Sankam. The learned counsel appearing on behalf of the petitioner submits that taking into account that the dispute involved, the petitioner would be well advised to file a revision in terms with Rule 32 of the Rules
for the administrations of justice and policy.
Michael side. Okay. Full stop. Taking into account the above, the instant petition stands closed, and he therefore submits that he would not like to press the instant writ petition without prejudice to his rights to prefer the revision application. Taking into account the above, the writ petition stands closed on withdrawal, liberty is given to the petitioner to prefer a revision in terms with Rule 32 of so and so, if so advised. Full stop. The withdrawal of the instant writ petition shall not prejudice the petitioner.
On the supplementary causes for motion, item number 15.
Lordship, this is the third round of litigation.
Third round.
I'll take your Lordship to the last order passed by this Honorable Court. And Annexure O, page 94, Your Lordship.
What are you challenging? Show me that first.
I am challenging the impugned letter which is at Annexure B.
Annexure, page?
118, Your Lordship. 118. This is a long, but essentially the last paragraph,
Just 1 minute.
page 120.
Like a subjective for the state of the highest regard of orders. Now you have been asked, you have been terminated.
No, I am still serving, Your Lordship.
In where? Where are you serving?
I am serving at Urangong A, that is
Under the
Long-
SSA scheme,
Under the SSA scheme, yes.
Sarva Shiksha.
Yes, Your Lordship.
Now, in these matters, if I am not wrong, there were certain proposals taken by the government at one point of time, by the Nagaland government, whereby they regularized a lot of employees and brought them within the ambit of
Yes.
the state, the
Yes.
state cadre.
Yes.
If I am not wrong, those are RMSA.
RMSA and SSA, both.
Both they have done it.
They have done it.
Now that they have brought it, but otherwise, if a person is working under the SSA scheme,
Yes.
it is more of it is a scheme of the central government, which is being done by the state government,
Yes, yes. Your
isn't it?
Lordship, yes.
But these are all contractual appointees.
Yes, there are many who are contractual appointees and then appointed in 2016, subsequent to the petitioner's appointment. And then
Now, what do you want here?
now what I want is the compliance of this honorable court's.
No, the question of this
then-
court directing regularization does not arise. But I think you need to develop your case in terms with Jago, the judgment of the Supreme Court, I think authored by Justice Vikram Nath, as well as the recent judgment, another judgment, wherein there are, yesterday I was also saying there is another very important concept, that if you are having a particular job which has a permanency in nature,
Yes.
you cannot have continue as a state to make them temporary. You have to give some financial some benefits, or otherwise the action of the state becomes unfair. You have to look at this. I'll issue notice, I think, but you may have to develop your case in that. But this case will have would have a very big implication. If you develop your case in that manner, it will have a very big implication. I'll just. This is a judgment delivered on 19th of August this month. I'll give it to them. I'll issue notice here, but the question of any interim does not arise here. But I think you try to develop your case in this manner.
Your Lord.
Hey, Satam, you give a printout to him so that he can give it to him. Huh? You take it from him. I think you develop your case. In that
Lord.
manner, huh? Issue notice returnable on 25th of September 2025. We are paying for all.
Doshi.
Ms. So-and-so accepts notice, appears on behalf of all the respondents and accepts notice. Extra copies of the petition be furnished to her during the course of the day.
Your Lord.
The petition herein is agreed by the continuation of the petitioner on contractual basis under the SSA scheme,
Ad hoc, Your Honor.
huh?
Ad hoc.
ad hoc, on ad hoc basis. In fact, it is contractual.
Yes, but the
Ad
appointment
hoc
order.
basis under the SSA scheme. And inaction on the part of the respondent authorities in creation of posts so that the petitioner could be accommodated. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, drawing the attention of this court to the recent judgment of the Supreme Court in the case of Dharam Singh and others versus State of UP and another, reported in 2025 SCC Online SC 1735, submitted. That this is not a case by which the petitioner is seeking a direction for regularization, but the petitioner herein seeks a judicial review on the inaction on the part of the respondent authorities in not creation of posts, taking into account that the petitioner has been performing works day after day on the same hands, on the same scale as is performed by permanent employees of the government of Nagaland. First, the Learned Council therefore submits that this is the third round of litigation, and on one ground or the other, the responding authorities have denied the rights, the legitimate rights of the petitioner. Mr. So-and-so, the Learned Counsel for the petitioner further submits that in view of the denial, the petitioner is not only deprived of various benefits which otherwise ensures upon a state government employee, but is also denied of the scale of pay which renders the action on the part of the responding authorities unfair and unreasonable and violative of Article 14 of the Constitution. First, the respondents are directed to bring on record their stand by filing their affidavits on or before the next date. So, this court also, having heard the Learned Counsel and having also perused, that this is, having also taken note of, that this is the third round of litigation, an endeavor shall be made for an early disposal, early resolution to the dispute raised in the present proceedings. Anything more?
Same order in the next.
Same order.
Same order.
So by this, you have already taken care of. I have 14 matters, 2 matters are gone.
Reply station.
So therefore, today I'll have to ask Mr. Longchar to take up the matter for a long time, one of the hearing matters.
For admission, item number 2.
Same one. Same one.
This is admission.
Oh, admission. Yes, what is this?
Your Lordship, here I'm challenging the appointment of the respondent number 7. I'm challenging the appointment of the respondent number 7, Your Lordship.
Setting aside.
Yes, Your Lordship.
Respondent number 7.
Yes, Your Lordship. He was appointed without issuance of any advertisement or conducting any selection
So
process.
let
Your
us set aside his appointment.
Lordship,
As we
But my
have-
lord, if I may be given some time to file reply to the respondent number 7.
Huh?
Your Lordship, if I may be given some time to file
You
reply.
want to file affidavit? Why?
Yes, Your Lordship.
I've raised the preliminary objections on the maintainability of the writ petition itself.
Why? Let us decide that.
So on the previous occasion also, they were asking for time to file the reply. So I was under the impression.
What is the preliminary objection?
Lordship, they have not challenged any orders in the writ petition itself.
What they have challenged?
The cost, let me take you to the cost title, Your Lordship.
Yes.
So I've raised preliminary objection on the maintenance.
Set aside the office order dated 27/4/2023. What is that?
No, Your Lordship, may kindly come to the page 1 of the writ petition. Your Lordship.
Page 1.
Yes, Lordship.
Yes.
The page 1,
Oh, it is because he has not mentioned this. Ah, don't go ahead. That is too feeble a preliminary objection.
and I've
You
also
see,
raised preliminary objections on the.
Mr. Counsel, whose mistake it is? Whose mistake it is? Her mistake. Can this court non-suit because of the mistake of the counsel? It is the counsel who should have known that she had to write out there after an application under Article 226 of the Constitution that the second should have been that for enforcement of the rights under Article the Part 3 of the Constitution, third for violation of the provisions of Article 14, 19 and 21 of the Constitution. Then she should have write the impugned order in the India matter of. It is not in the form of the Gauhati High Court rules, isn't it? But who will know that? The lawyer. So why are you troubling that lawyer?
That's one part of the.
Okay, so that is
objections.
rejected. Next.
Lordship, the other one is suppression of material facts, Lordship.
Oh, that is a very serious one.
Yes, Lord.
That is, which one, why are you saying suppression of material facts?
Lordship, on 2 grounds, suppression of material facts. Lordship, firstly, the petitioner is applying for land ownership basis. However, he have suppressed the standing OM notification of the state government which provides for appointment on the land ownership basis. Because the petitioner is well aware that under the scheme, he doesn't come under the scheme. So the petitioner have already, they have deliberately suppressed that very fact. However, in the prayer, they are seeking for land ownership basis without specifying any notification or the standing memorandum of the state government, knowing well that she doesn't come under the scheme. So there's clear suppression of material facts. Also, as we go through the affidavit in opposition of the state, there's
Why does the petitioner does not come within the ambit of that notification?
Yes, I'm coming to that. One point is,
Because to be suppression has to be material facts,
yes, Lordship,
not facts.
yes, Lordship.
So it has to be material facts. So
Yes.
it would be material only. You have to say that why it is suppression. It becomes a material fact.
Yes, Lordship, I'm coming to that. Also, to add to that, 13 appointments have been made on land ownership basis over that plot of land. That has been suppressed. And
But the fact remains as to whether from her family anybody has been appointed. That's the material fact.
that's the affidavit. That's what the affidavit talks about.
Whether your affidavit or the state's.
State
Let
affidavit.
us see that.
So there is clear suppression of material facts.
No,
By the
let us
petitioner.
not go by that. Let us see what is the affidavit filed by the state.
Your Lordship, it's in the additional affidavit
Yes, Ms.
filed
Saimi.
on 27/8. Additional affidavit, Your Lordship.
Respondent
Filed on
number 7?
27. No, Your Lordship.
Whose affidavit?
State affidavit.
Additional affidavit.
Yes, Your Lordship.
You have not filed a reply and you have filed additional
No,
affidavit.
Your Lordship, I filed an affidavit also, but
Okay,
there nothing
affidavit.
much is there. It's just
I
about
see
the
two
OM.
additional affidavit in opposition. Okay, now which one do you are you relying upon?
Additional affidavit
Dated
filed on 27/8 of 24.
27/8/2000. Yes, 28/8/2000. Yes, what is it?
Your Lordship, here I have stated that on the basis of land
The
ownership,
appointment to the post of martyr under the executive under the vacancy of AS7 applications were received, including the petition and the respondent number 7. The petitioner never mentioned in her application that is applying on a Iman. Moreover, the respondent was appointed under the approval from the government. As the respect the Iman received from the Iman, so far 13 appointments have been made on one member of the Iman. 13 appointments. But you didn't say out here that these 13 appointments who have been made belongs to anybody who belongs to the family. Because otherwise, you want to bring in 3C.
yes, Your Lordship.
If you want to bring 3C of the notification, it means that there cannot be an appointment in perpetuity.
Yes, Your Lordship.
So therefore, somebody from her family has to be appointed.
Yes, Your Lordship.
Where have you mentioned?
Your Lordship, but moreover, there has been no agreement, the landowners and the
That is,
government.
if it is no agreement, then it will be seen in terms of 3B. Have you carried out has the Deputy Commissioner carried out the exercise in terms of 3B?
No, Your Lordship, that has not been
So
done.
then, therefore, the basis, more particular basis that you have to come up with specific, that yes, her family has already received the benefit in terms of the land ownership basis, or she is not entitled as per the land ownership basis. You say in paragraph number 3 that look here, we have received 7 or 13 applications or whatever may be, we have got many applications and the petitioner never applied in terms with the land ownership basis. Whereas respondent number 7 applied for the land ownership basis and you have the approval of the government. That's what is mentioned in paragraph 3, if I'm not wrong.
Your Lordship, respondent 7 was not on land ownership basis. He applied for the post.
No, here you say where applications were including, you say against that the post of so and so against the vacancy has 7 applications including the petitioner never mentioned in her application that she was applying on land ownership basis. So and so was appointed on the approval from the government. Now, if a person is appointed not on the land ownership basis, then you have to follow the mandate of Article 14. Have you followed that?
No, Your Lordship, that was
Then-
not done.
What is the material fact suppressed? Good case. You don't require to file affidavits. We allow your petition like this.
Lordship,
Only on account of land ownership basis, one can very well say. But the fact remains that the petitioner had applied, so petitioner knew about it. What is the justification of appointing the respondent number 7? Where is your affidavit for that? There has to be some selection committee. Or is it out here that the government will say that, okay, well, I like him, so appoint him. Then the concept of blue-eyed boy, blue-eyed girl will come in. Is it something like that? What is your justification why you have appointed respondent number 7?
Your Lordship, I've only stated that it was done on the approval of the government, Your Lordship. That's all.
If the approval is given by the government, so therefore are you saying that the government has directed you to appoint? Where is there any selection proceeding? Some selection proceeding has to be there, madam.
Yes, Your Lordship.
And that is why madam is aggrieved. See? Good case. So we reject your preliminary objections. Let me do some work. And then tomorrow we finish up this entire thing. Today you may not be ready with the merits.
I have some difficulties this week. If the matter can be listed Thursday or Tuesday, I have some particular emergencies.
So on Friday we are having.
No, till Monday.
So today we finish it.
The matter can be listed on Tuesday.
No, today. If you have problem, I am giving you an opportunity for preparing more after rejecting your preliminary objections for deciding in tomorrow. If you say that you have difficulty tomorrow or day after, we'll have it today.
Your Lordship, on Tuesday.
No. Tuesday, a lot of matters have been fixed. Ask your additional advocate general how many matters we have fixed yesterday, on Monday, Tuesday. One judge, how many matters he can fix? So, madam, just tell me one thing. Is there any selection proceedings in respect to respond number 7?
No, Your Lordship, that was not done. It was just done on the basis of government approval.
So then we need to set aside this. Go for a selection because we were not appointed on land ownership basis. So therefore we need to set aside because this is not backed by any contemporary records. And go for a fresh, she is not entitled to. I'm not going to give it to her. But the fact that this has to be set aside and you have to carry out, isn't it, madam? That you cannot go by this way. So, let's dictate. Chalo. Heard Miss So-and-so, the learned counsel, appearing on behalf of the petitioner. Miss A. Ayamin, the learned counsel, appears on behalf of the respondent numbers 1 to 6. Mr. So-and-so appears on behalf of the respondent number 7. The petitioner herein is agreed by the order dated 27/4/2023, whereby the respondent number 7 was appointed as a multitasking staff (MTS) peon under the establishment of the Executive Engineer PWD R&D Changtongya Division Mokokchong. The petitioner have also sought for certain directions that the petitioner should be considered on the basis of land ownership basis and thereupon preference be given to the petitioner. For deciding as to whether the petitioner's case merits consideration, it is relevant to take note of the facts which led to the filing of the present petition. First, on 6/7/2021, one Swim Imtisilu expired in harness while working as a peon under the establishment of the respondent number 6. Upon his death, a vacancy arose in the establishment of the respondent number 6. The petitioner, on coming to learn about the vacancy, submitted an application to the respondent number 5 on 27/2021. Footstep. It is the case of the petitioner that in the said application so filed by the petitioner on 27/2021, the petitioner had made reference that she was the landowner of the office and a good citizen of Sangtongya village. Along with the said application, the petitioner also had submitted a communication, a certificate issued by the chairman of the Sangtongya Village Council dated 18/7/2021, certifying that the petitioner is the rightful owner of the site where the building and the godown of the SDO, PWD Changtongya was constructed. First, the grievance of the petitioner is that the petitioner's application was not considered. Rather, the respondent number 7 was appointed by the impugned order dated 27/4/2023 as a multitasking staff MTS in the establishment of the respondent number 6 in the vacancy which arose out of the on account of the death of late so and so Intisilu. It is under such circumstances that the present petition was filed by the petitioner on 26/7/2023. The record reveals that the respondents, number 7, the respondents, the official respondents have filed an affidavit in opposition on 16/2/2024 and further an additional affidavit in opposition on 28/8/2024. In the affidavit in opposition filed by the respondent numbers 1 to 6, it was stated reference was drawn to the OM dated 3/3/2022. But there was nothing mentioned in the said affidavit in opposition as to why preference was given to the respondent, why the respondent number 7 was appointed by the impugned order dated 24/7/2023. In the additional affidavit in opposition so filed by the respondent numbers 1 to 6, pursuant to an order passed by this court on 1/8/2024, it was mentioned that the petitioner did not apply on land ownership basis. The only aspect which was mentioned as regards the appointment of the respondent number 7 was that the respondent number 7 was appointed in view of an approval given by the government by the letter dated 4/1/2023. It was further mentioned in the said additional affidavit in opposition that 13 appointments have been made on the basis of land ownership from amongst the landowners under the said division. First, this court had duly heard, first of all, this court further duly takes note of that the respondent number 7 had filed an affidavit in opposition. Wherein various preliminary objections were taken as regards the maintainability of the writ petition. The preliminary objections which were taken were that the drawing up of the writ petition was not in terms with the Gauhati High Court rules. And further, there was suppression of material facts. It is further seen from the affidavit in opposition filed by the respondent number 7 that the respondent number 7's credentials were placed along with the application filed by the respondent number 7 on 10/11/2022 for appointment against the vacant post of the peon in the office of the respondent number 6. But at that point of time, oh, okay, 10/11. But you filed on 27/2021.
Yes, Your Lordship.
Yes. And they filed on 10/11/2022. Huh? 10/11. First. In the backdrop of the above pleadings, let this court now consider, this court have duly considered the submissions so made by the learned counsels appearing on behalf of the parties. First. Before touching on the merits, this court finds it relevant to take note of the submissions so made by the learned counsel appearing on behalf of the respondent number 7 on the preliminary objections raised as regards the maintainability of the writ petition. The first preliminary objection which have been taken is that the writ petition was not drawn up in the manner set out in Chapter Roman 5, capital A of the Gauhati High Court Rules, 1954. First. In the opinion of this court, that not drawing the writ petition in the manner as set out in the Gauhati High Court Rules is not the fault of the petitioner, but it is the fault of the lawyer. Additionally, it was also the fault of the registry in accepting the writ petition when it was not drawn up in the manner in which it ought to have been drawn up. On that respect, however, it is the opinion of this court that the petitioner cannot be non-suited. More so when the petitioner alleges violation of her fundamental rights and constitutional rights. The second aspect, the second preliminary objection which have been taken is that there was suppression of material facts. It is relevant to take note of that the petitioner can be non-suited when there is a suppression of material facts. But the facts which have been suppressed it is relevant to take note of. That all facts are not material facts. And it is only when there is a suppression of material facts then a petitioner can be non-suited. First, In the same context, let this court now deal with as to whether the petition suffers from suppression of material facts as have been submitted by the learned counsel appearing on behalf of the respondents. Respondent number 7. The learned counsel appearing on behalf of the respondent number 7 submitted that the petitioner have not brought on record the notification dated 3/3/2022 issued by the government. And as such, it was a suppression of material fact. The second submission so made is that the petitioner have not disclosed that there were already 13 appointments made on land ownership basis in the establishment of the respondent number 6. In the backdrop of the above, let this court now deal it as to whether the said aspects, would constitute material facts. First, the petitioner herein, it is very pertinent herein to take note of that the petitioner had submitted her application on land ownership basis on 27/2021, much prior to the OM date. Is it OM or notification?
OM.
OM.
16/8.
Is it notification or OM?
OM.
OM. OM dated 3/3/2022.
OM.
Your Lordship, it's OM dated 16/8/2018.
16/8.
For land ownership basis.
Now she has brought on record something. Where? No, you are referring to the OM dated 3/3/2022 only in your affidavit, madam. See your affidavit in opposition filed on 16th of February.
Your Lordship, in the prayer of the petitioner.
Oh, okay. Yeah.
She's
Okay. OM dated. Legally. Let us go first take into as to whether whether reference not made to the office memorandum dated 16/8/2018 can be considered to be a suppression of material facts. First, a perusal of the writ petition would show that the petitioner had applied on land ownership basis. First, when the petitioner had applied on the basis on land ownership basis, it would be deemed that there is an existence of a policy of the state on the basis of which the petitioner claims rights. not bringing on record the said policy which is brought on, which is notified by the office memorandum dated 16/8/2018 in the opinion of this court cannot be said to be a suppression of material facts.
Lordship, there's not even a statement of existence of a policy, Lordship, in the writ petition.
She is claiming on the basis of land ownership, meaning thereby there is an existence of a land. Why will somebody claim? In Gauhati, in Assam, can you claim?
No,
No.
Lordship.
But here you can claim because there is an existence.
Yes, but in her statement, there is no statement saying that there's a
She is
policy.
claiming on the basis of this office memorandum.
Yes, there's no statement.
Not necessary. On the basis of some policy, she is claiming. The second aspect, pertains to as to whether non-disclosure of the fact that there were 13 appointments made on land ownership basis would be a suppression of material facts. First, it is very pertinent to mention that though the state respondents have stated that there were 13 appointments made to the establishment of the respondent number 6 on land ownership basis, but there was no mention in the pleadings of the state respondents that any of the persons who were appointed were related to the petitioner's family. Under such circumstances, the said aspect cannot also be said to be a suppression of material facts. It is further very pertinent to observe that as per the state respondents, the petitioner did not apply on land ownership basis. And this aspect would be seen from paragraph number 3 of the affidavit in opposition, additional affidavit in opposition filed by the state respondents on 28/8/2024. If that be so, the preliminary objections taken as regards non-disclosure of the office memorandum dated 16/8/2018, as well as non-disclosure that there were 13 appointments made on land ownership basis in the establishment of respondent number 6 have no relevance. Next. This note further takes now coming into the question of merits. This note specifically inquired with Ms. A. Ayami, the learned counsel appearing on behalf of the respondent numbers 1 to 6, as to on what basis the respondent number 7 was appointed by the interim order dated 24/7/2023, with the learned counsel, Ms. Swenso, with all her fairness, submits that the respondent number 7 was appointed in view of the approval from the government dated 4/1/2023. This court further inquired as to whether there was any contemporaneous records maintained in respect to a selection being carried out, taking into account that the petitioner also had submitted, there were 7 applicants who had submitted. The learned counsel submits that there is nothing to that regard. Next. The respondent number 7 was appointed to a public post. And as such, it is the mandate of law that the respondent authorities have to abide by the mandate of Article 14 and Article 16 of the Constitution. First, merely on the basis of an approval being given by the government, which is not supported by any selection proceedings, maintained selection proceedings maintained with contemporaneous records. Such appointment would be in violation to Article 14 and 16 of the Constitution. Accordingly, it is therefore the opinion of this court that the impugned order requires interference as it violates the mandate of Article 14 and 16 of the Constitution. Consequently, this court therefore disposes of the present petition with the following observations and directions. The impugned order dated 24/7/2023, by which the respondent number 7 was appointed as a multitasking staff in the establishment of the respondent number 6 is set aside and quashed. Number 2, the respondent authorities are directed to carry out a fresh selection process as per its policies, as per its extent policies, EXTANT, extent policies, and fill up the said post. Okay, no trouble tomorrow. There shall be no order as to cost.
For admission, item number 3.
Yes.
Lordship, on the last occasion, there was this one counsel. He served
What is the
time-
matter about?
It's regarding pension benefits.
You are appearing for the respondent.
Yes, Lordship, for the state respondents.
Out of fear, other side is not appearing.
Lordship, they sought time to file Vakala Namala on the last occasion, Lordship.
Let us see how can we
Lordship.
to release the monthly pension from the date of retirement. Direct the state respondents to pay pension arrears with interest. Is he entitled to pension? What is your stand?
Lordship, Lordship, on date
You have
5.
filed your affidavit, no?
Yes, Lordship.
Let us see what is your stand. Affidavit in compliance to the service.
File on
It's the
90,
pension
2024.
papers of the widow was forwarded to the accountant at South Plain. South Sampere and returned the pension papers and the VA was appointed in a constituent exigency of service and government. He was appointed in the exigency of service and because the corresponding to furnish certain documents. Sent according to the So the department has done for the purpose of what is the accountant general saying? The problem must have been done by the accountant general.
Yes, Lordship. Accountant General was also made a party, Lordship.
Huh?
Accountant
He
General.
was appointed, this is his service book, na?
Yes, Lordship.
But they have changed the name.
Yes, Lordship.
An Angami becomes a Singh. How is it possible?
Yes, Lord.
Huh? Is it ever heard of?
No, Lordship. Initially, it was Zaniso Angami, Lordship. Then he changed his name to M. Pimani Singh, Lordship. He changed
How is
his
it
name.
possible?
My lord, here the
Isn't it the most
counsel for the
interesting case?
petitioner
Huh?
had withdrawn the
Counsel for the petitioner had withdrawn. No, it's okay, but the fact remains, it's a case of pension.
Yes,
One has to be more careful on that. I can't dismiss for default like
my lord,
this.
the
But the only thing is, how a Angami, who is a Naga, becomes a Singh and becomes Manipuri.
no, my lord. Initially, he was appointed in the name of Naga.
Then how does he become Manipuri
And
then?
he is trying to come with a plea that his name should be changed.
No, have you seen this?
Yes,
The
my
service book.
yes, my lord.
His name is some Angami. Then he wants to change the name to M. Birimani Singh.
After retirement.
Then his caste and religion, which was Angami and Christianity, becomes Manipuri and Hindu. How is it possible?
Not Meghalaya.
Huh? But he worked for 20 years. Enlistment on 1/4/94. Date of birth was 57.
He was appointed even
20 years. He rendered service. And they have made the Accountant General also a party. Who appears for Accountant General?
They have never appeared, Lordship.
Because you must have been submitting the documents to whom? For condonation of his age?
To the PNR, Lordship. To the PNR.
To the
PN,
PNR.
PNR.
PNR is personnel and
Administrative reforms.
personnel
And administrative reforms.
PAR.
PNAR.
And administrative reforms.
Yes, Lordship.
Who is appearing for the personal and administrative reforms? You.
we are appearing for all the state
Yes,
respondents.
Lordship.
So therefore, what have you taken as regards the
We
condonation?
have already filed our affidavit.
No, that affidavit I have shown. They say that we have submitted. That is the affidavit.
Yes, ma'am.
We have submitted to these people
Yes, ma'am.
for the purpose of condonation of his age. Because at the time of his appointment,
Yes, ma'am.
he must have been 57, 97 will be 40. He was 38 years, 37 years.
He was appointed much after his overage.
No, he was appointed at 37.
Yes, ma'am.
37 or 47? 94 minus 57, what would be the how much? 94 minus 57, that is 7. And yeah,
37 Lordship.
37?
37 Lordship.
37.
Yes, Lordship.
But 37, is it overage?
Yes,
If it is scheduled tribes? That is the problem, na?
Point of time, the maximum age should be 30 years for entry to the government service.
No. That is, I think, that's wrong. Maximum age for SC, ST is different.
Yes.
OBC is different.
Yes,
35 years.
They are given certain benefits under 342. So therefore, there would be, in Assam it is relaxed to 45. But for police it may be different.
yes, ma'am.
But the fact that he has rendered service for 13 years, here's 6 years plus another 17, 21 years he has rendered service.
Yes.
17, 23 years. If you have rendered service for 23 years, can you deprive him of his pension? I think you should do something.
We have filed our affidavit.
Now that affidavit I had said, only one affidavit has been filed.
Lordship, if sometime you can so we can get some instructions from the PNR, Lordship.
There's only one affidavit.
Yes, Lordship.
Yes, one young advocate who wants to be an amicus here to help this court.
My lord, earlier, my
Earlier it's
friend-
okay. This court will just appoint an amicus so that that lawyer also gains some knowledge about this matter, na? How it is being done. You see, the pension thing is, it's not a bounty of the state. It is a fundamental right. Getting a pension is a fundamental right. It's not even has the status of a statutory right.
on last 11 of this month, one Mr. K. Naki appeared.
Forget about them. Nah. If he is not appearing, somebody has to appear. So that you see, there's no problem for this court to dismiss it for default. But we didn't do proper. It's a pension. Nah. People will laugh. What has happened to the Gauhati High Court? Dismissing pension matters for default.
My lord, the fact of the case is that initially he was appointed in the name of Naga.
Yes, that is the only worry.
Yes, ma'am.
That we have rejected
For
it.
several years, he tried to change his name to Permanising.
No,
Which
he
is
not
not
only
possible.
changed his name, he changed everything.
Yes, ma'am. Religion.
Because here, but these certificates which have been given,
Yes, ma'am.
but all these things have been changed. Unless you are challenging his appointment, would he not be entitled to pension? This is never heard of, but this has happened.
Only when he was trying to claim for pensionary benefits, he tried to change his name from Naga to Permanising.
But Mr. Counsel, Mr. Santam, kindly do see one thing. There has been so appreciation in his service book. It must not be proper. You have the service book, Mr. Santam?
Yes, ma'am.
Have you seen the service book? Following NGOs and ranks of the bland were awarded high commandants in dedication of year the commandants were pleased to award rupees 30 to so Biram Singh and Koi. People have served for the country. You should do something. Well, it's only the condonation is required. Condone that and I think he can get it done. Something has to be worked out, isn't it?
If that be the case, my lord, PNAR approval is a must. PNAR.
So you exercise your good office.
And at the same time, changing of his name after much years have been passed in service.
But then also you have rejected that.
Yes,
The name has been rejected.
Yes, ma'am.
But he has changed his name. But however, this person has worked. These things can be very well taken care of now. Because your own commandant of the 5th Naga AP Battalion have done that.
My lord, on the ground of non-appearance by the petitioner's counsel, last occasion, one Mr. Naki appeared, but today he has not appeared. Earlier,
Mr. Santam, there is no problem, but this court does not have any intention of dismissing a pension matter. That too when he is entitled to. It is a fact that he worked. It is a fact, all these documents show that he worked. This person has also been given a lot of medals also, medals or awards, as you can see from his service book. Then when he has done 23 years of service, now everything at the time when he is retired and done everything, would it be nice on the part of this country? I'm not saying about any civil post. He has worked in this particular, he has served the country in that your state, the Nagaland, AP, Armed Police.
Yes, ma'am.
He has rendered service for 23 years.
He served as a tailor. He served as tailor, not
Tailor.
the armed service.
Tailor?
Yes, madam.
How do you know?
He was not
Constable, no, enlisted as constable's tailor.
tailor.
Huh?
He was not in the armed service. He was a tailor.
Tailor.
Yes, ma'am.
But tailor also good. Tailor is also important. Good tailor, very good turnout, good tailor, so many good tailors given in his ACR.
We have filed our affidavit. However, we may be granted 3 weeks' time, madam, to seek more instructions.
No, I am not here for 3 weeks. I am here only for this week and next week. So instruction is next week. Something good has to be done. How can we resolve the situation is the thing. Let us not, you see, this is a pension matter. We should not be going against this. Because this is, after all, he has rendered service.
Appearance of AG is a must, ma'am.
AG?
Yes, ma'am. Accountant General.
Where is it? Mr. Moju is the AG? Who is nowadays AG here? AG? Who appears for AG? AG, another person appears. Joshua. Seki appears, na?
Shaky as well as Yamavati. Shaky.
There are two persons, Mr. Moju and Mr. Seki.
Yes, ma'am. Yes.
Okay. And Mr. Seki's junior was here long after, for some time. The earlier matter was Mr. Seki's junior, na? You are there?
Yes.
AG, let's get your instructions. What have you
However,
done?
my lord, in the course title, the
Heard
AG is not
Mr. Engage
reflected.
and newly engaged counsel, Mr. Singh, yeah, because I think they have made the AG a party.
Yes, sir.
Yes, AG has been made a party.
Earlier,
Oh, yes. Amended petition.
Respond number 4 and 5. Oh, you are not appearing?
Actually, we haven't got any information. We didn't get any information.
It is seen that the respondent number 4 and 5. How is that? Where? Item number? 3. Okay, it is seen in the cause list. The names of the counsel appearing on behalf of the petitioner as well as the newly implemented respondent number 4 and 5 have not been shown. So accordingly, list this matter again on 1st of September 2025. The registry shall show the name of Mr. K. Nagi, the learned counsel for the petitioner, and Mr. J. Saki, the learned counsel who represents the respondent number 4 and 5.
much.
Item number 4.
This, my lord. My lord, I'm mentioning on behalf of Senior Yang, waiting for the respondent number 5, my lord. Yes, my senior is having a fixed matter in the courtroom, my lord. I read it.
Mr. Gauhati was here.
Yes, my lord. He's in the other court, my lord. Having a fixed
Sir,
matter.
don't worry. Before dictating and finishing of the judgment, if your senior arrives, good. Otherwise, I'll put your appearance.
Yes, your
Are
lordship.
you?
May I please, my lordship? Lordship, here the petitioner is seeking for the pending bill for
Contract
the
matter, Department of Tourism. What is the matter about?
seeking the pending bill, Lordship, for the contract work. Yes.
17,54,620. What is the affidavit filed by respondent number 4? The completion of a biological dated meal seeking for release of the parent answer I have also made. They will request verbally for release of the pending bill, however, the answer is instead directed by the state respondent to approach the yes. Mr. Counsel, these are all disputed questions of facts.
Lordship.
Disputed questions of facts.
Lordship,
First, they don't admit that any work order has been issued. Then they say that the installment has been paid to some construction. They have not completed the work. This happened long time back.
yes.
And now in 2023, you open your eyes.
No, Lordship, it's because we have been verbally approaching them or
There
sending
is no
letters of
verbal
letters.
approaching, and verbally you have to, you see, somebody has to maintain records. Where will they maintain records?
Lordship, we
When
have,
did you complete the work? 2015.
yes, Lordship.
They categorically say that there is no work being given to you.
Lordship, they have given us the work, Lordship.
Kindly see it in their affidavit.
Work order annexure A, Lordship.
No, Annexure A 2000, the petitioner stating that the work commenced on 26/6/2003 and completed is denied. Then, when it is denied, how can this court decide on affidavits? Oh, civil court. Okay. So before your senior comes, the judgment will be delivered again in favor of your senior.
Lordship, but we have completed the work and they have issued the first installment too.
No, I can't help you with this. Lekhok, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Who appears for the respondent number 1 to 4?
I'm for responding 1 to 4, Lordship.
Mr.
Ejimon.
Jimomi appears on behalf of the respondent numbers 1 to 4. And Mr. Gauhati appears for respondent number 5.
CGC.
The petitioner hearing has approached for release of the pending bill amounting to rupees 17,54,620 along with interest at the rate of 16% per annum. It is the case of the petitioner that a work order dated 17/1/2015 was issued to the firm for an amount of rupees 21 lakhs for development of the tourist circuit at DZU. Des Shakha CHAKHABAMA Kekruma in Nagaland for construction of the wayside amenity of Junkaki River Bank. Itu inverted commas of development of here. It is the case of the petitioner that the work commenced on 26/6/2015 and was completed on 29/2015. It is the further case of the petitioner that the proprietor of MS Hong Kong Construction, to whom the work order was issued, had authorized the petitioner by way of a power of attorney to undertake the full responsibility for work on execution, bill receipt and payment, etc. It is the further case of the petitioner that only an amount of rupees 3,45,380 was received and the remaining amount of rupees 17,54,620 remained pending. First, 8 years thereafter, on 26/5/2013, the petitioner submitted a representation requesting for issuance of completion certificate and release of the pending bills at the earliest with an interest of 16%. Thereupon, the petitioner issued a legal notice on 28/6/2023. However, having not received any reply, having not received a favorable response, the petitioner had filed a writ petition, had filed the present writ petition. It is seen that the respondent numbers 1 to 4 had filed an affidavit in opposition on 13/5/2025, stating inter alia that the work order dated 17/1/2015 was awarded to MS Hong Kong Construction out of different work components sanctioned by the Ministry of Tourism, Government of India, under the Product Infrastructure Development of Tourism, Destination and Circuits. It was specifically denied that the work commenced on 26/6/2015 and completed on 29/2015. It was further mentioned that the question of issuance of permitting the petitioner to work on the basis of a power of attorney did not arise. And in fact, MS Hong Kong Construction had violated the terms and conditions of the work order. First, it was further mentioned that an amount of rupees 3,45,380 was released for the only portion work executed. It was further mentioned that the remaining from a perusal of the said stand so taken by the responding authorities, it appears that the entitlement of the petitioner have been disputed, and it is the opinion of this court that such disputed questions of facts can only be adjudicated in a forum where evidence can be led. So, considering the above, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed.
Lordship, if you may kindly check our affidavit in reply.
Be that as it may, the petitioner herein is given the liberty to proceed to invoke appropriate remedies, if so advised, wherein, before appropriate forms, wherein evidence can be led and the disputed questions of facts can be adjudicated. It is observed that if the petitioner duly appears before, the petitioner duly approaches the appropriate forum, the period during which the instant proceedings have been filed, that is from 14/12/2023 till date, be excluded while computing the period of limitation.
For admission, item number 5.
May I please
Yes.
Lordship, I've received affidavit in reply only just now.
What?
I received affidavit in reply from the state respondent only just now.
It was filed on 13/6/2025, long time back.
I received just now, Lordship. So I need some time to
Now
rest.
let us see what is their case, your case.
Lordship,
We won't look into the affidavit in reply filed by anybody. Let us see only the affidavit in opposition, which was filed on 19th August, something has been filed. But affidavit reply to the rejoinder affidavit by the petitioner.
Lordship,
Let us see what is the case of the petitioner. Yes, madam, what is your case? Land ownership.
Yes, Lordship. I'm seeking grade 4 post on the grounds of land ownership.
Land ownership.
Yes, Your Lordship.
You have donated the land.
Yes, Lordship.
Now what happened? They are not giving it. Why they are not giving? Let us see the affidavit in opposition. But madam, now 6733 cannot apply now.
Lordship, actually, I'm not in this case, Lordship.
You are not there?
No, Lordship. As Mary, she's appearing, but she's engaged in court.
No, none appears for the government. Very good. You don't have an opposition also. You pass the order and say then none appears for the government and this.
Lordship, if this matter can be taken up after some
No,
time,
no, no.
Lordship. She's engaged in court.
No, no, matter has to be finished immediately. What is the affidavit in apply file? Very good. Madam, we do one thing. We direct the, you want on the land ownership basis. Okay, is there any vacancy?
Yes, the respondent number 3 is already retired in the month of March, Lordship. Respondent number 3, private respondent is
No,
already retired.
private respondent has been appointed.
Already retired in the month of March, Lordship.
Respondent number 3 has been appointed.
Already retired, Lordship.
Retired.
Retired.
Respondent number 3.
Yes, Lordship. In the
So
month of
now a
March.
new post.
Yes, yes.
So it has to be now filled up.
Yes, Lordship.
So
It's
you have
vacant
come before. When did the respondent number 3 retire?
in the month of March this year.
March 2020.
25, Lordship.
Who is appearing, madam, in this government?
As Mary, Lordship. As
Eh?
Mary.
She's not here.
She's engaged in court too, Lordship.
Okay, we'll take it up at 2. At 2 I have a video conferencing, 2:30.
Lordship.
We'll take it up. Because now what has happened as regards respondent number 3 is okay. As regards there is a vacancy which has arisen. Now this vacancy has to be filled up. Now whether you want to do it by land ownership basis, whether or not, you consider as to whether let the petitioner submit an application. You don't have a written agreement.
No, Lordship.
So it has to be done in terms with 3B of the office memorandum dated 16/8, isn't it? So let the deputy commissioner look into that aspect, and while filling up the post, let her, because now it's a fresh post has arisen.
Yes,
So
Lordship.
that has to be filled up.
Yes,
Now you better file an application on land ownership basis.
Lordship.
And I direct the deputy commissioner to consider in terms of 3B of the notification and dispose of the writ petition. I think that is, your right is there, but this court cannot direct your appointment. This court can look into if the appointment is illegal to somebody, but that person is already retired. So therefore, that would be a better order. Okay?
Yes, Lordship.
During your lunch, you ponder and think about it, whether I am right or wrong.
Yes, yes, Lordship.
Obliged, Lordship.
Much obliged, Lordship.
No, please, Lordship. Lordship, I'm making mention on behalf of the counsel for the respondent, Z. Kulnu, who is in bereavement manner, Lordship.
Who?
Z. Kulnu, Your Lordship. Z. Kulnu, on behalf of the counsel for the respondent.
Tax matter.
Lordship.
What is the matter about? Who is the petitioner?
My lords, I'm appearing for the
Who
petitioner.
is the petitioner counsel?
Lordship, leading counsel is
Huh?
appearing through VC.
Yes, I can hear you. Where's your, what has happened to your sound? So, no,
audible, my
what are you challenging? Impugn notification dated so-and-so is unconstitutional. My goodness. P. Agarwal as so-and-so, in the Indian considering the so-and-so, the division bench as well as court bench of this Iman is so-and-so shall remain suspended. Why it will be remain suspended? Which
My
order?
lords, they're challenging
Here the other side, so obviously.
Lordship,
54.
next 30. Page number 350.
You are petitioner?
Yes, sir.
Okay, page
Page 350.
350. Okay, now tell me, you have an alternative remedy in appeal. Why are you not going there?
My lords, the GST tribunal is still not operative, my lords.
We are not going to entertain this type of writ petition. We dismiss the writ petition on that basis.
My lords, please, my lords, we have already. Am I audible, my lords?
Why we are not hearing her sound? From your end, the problem is, tell your person.
My lords,
Everybody can hear, you must have put yourself in mute.
my
Unmute
lords, we have
yourself.
already.
Okay, we can't hear, so we close this petition on that basis. What is the challenge here?
My lords, am I audible, my
GST
lords?
of rupees so and so, confirm the input tax credit at charge so and so in so and so. Good. File appeal. No case.
My lords, GST appellate tribunal still not operative, my lords.
What is your case?
Lordship,
Let's see the division bench order where there is some reasons. Who is appealing for GST?
Lordship, Z Kunglu, Your Lordship. Z Kunglu.
Huh?
Z Kunglu.
Where is he?
He's in bereavement, Your Lordship.
Don't
My
worry.
lords, am I audible, my lords?
But,
Lordship.
you will happily accept the dismissal of the writ petition? Shall
Lordship, on the last occasion, the Honorable
My lords,
Mission Pence also gave
Show me the division bench order. But these points you can very well raise there. I give you the liberty, go and raise all these points out there.
pass over.
But Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the... Yeah, Mr. Yangavati?
No,
He appears for respondent number?
all the respondent, Lordship.
How can he appear for all the respondents? One is central respondent.
My lords,
Yeah, Your Lordship. CBIC.
Huh? Okay. Mr. So-and-so appears on behalf of all the respondents.
On behalf of Z Kunglu, Your Lordship.
Huh?
On behalf of the leading counsel, who is Z Kunglu.
Mr. Yangavati, you will be appealing for the central.
GST. So GST, we have a separate council.
my lords, am I audible, my lords?
Huh?
Department, we have a separate council.
Okay.
My lords, am I audible?
Lordship, this is
My lords, am I audible?
I can't hear you. So you have taken the risk of not coming before a court out here, which is very difficult. And I am a person who regularly deals with tax matters. We have been very fortunate to get a stay all this while.
Lordship, pass over for the moment.
My lords, please pass over, my lords.
Mr. Gulda, his leave has been reflected in the cost list. Mr. Gulda, Senate Council, his name has been reflected in the cost list for leave of absence.
Okay. Now, I am not passing an order against the state. I am dismissing the petition on the ground of non-entender.
Lordship,
I am not
pass over for
entertaining this petition. You have to file an appeal. Why you are not filing an appeal? You can't
My
come
lords,
here and
appellate,
get a stay out there.
my lords, GST
can't help
appellate
it.
authority is not operative, my lords.
Yes.
My lords, the matter is already covered, my lords.
Okay, we'll have it tomorrow. Leave the
Okay.
matter tomorrow.
Thank you, my lords. Thank you.
I'm not inclined to extend the interim order. Tomorrow, leave the matter tomorrow, taking into account that the counsel appearing on video conference could not be heard. To stop the counsel appearing on behalf of the petitioner through video conferencing lead could not be heard. To stop. List the matter tomorrow.
Oblige, Malord.
Item number 7.
May I have His Lordship, my lord, here I'm appearing for respond number 5, 6 and 7. My lord, here I'm yet to receive
What is the
instruction.
case?
My lord, I'm yet to receive instructions, so kindly allow me 3 weeks time, my lord.
What is he asking for?
Lordship, the matter pertains to
For
land
compliance with the
compensation.
statutory provisions of the Nagaland Requisition Act for payment of rent with interest and also for payment of life followed by requisition income. How many years it has been under requisition, madam?
Since 1986.
Huh?
Since 1986.
98.
1986.
I'm not clear. 90?
1986. Still that.
1986. 86.
86.
Yes.
We have kept under requisition.
No, my lord, as per the petitioner's submission that the land has not been...
No, I'm asking you, are you keeping the land under requisition from 1986?
No, it is the Assam Rifle
Yeah, the
who is
Assam.
occupying the land, my lord.
It may be even the Prime Minister's office. I'm not concerned, but I'm asking you, are you keeping the land of the petitioner under requisition from 1986? If you are keeping it, it is a fraud on the power which is being conferred. Because there are not 1, 7, 8 judgments of the Supreme Court that there cannot be a permanency in respect to requisition. It has to be either acquired. If you, an acquisition by way of a requisition, you cannot carry out a form of an acquisition.
Yes.
There are many judgments to that effect. So, whether you file your affidavit or not, I'm not bothered out there. I think you should vacate immediately. It's a fraud.
My lord, I'm appearing for...
4, 5 judgments.
My lord, I'm appearing for the state respondent, and the Union of India is appearing by...
There are some efforts.
Yes, for Assam Rifles, but I am occupying the land on behalf of the, as per the lease or written.
And the state has given the lease.
On, yes, so that, on that basis, I am occupying.
And state have requisitioned the land from the petitioner.
That I don't know.
So that is why I need instruction, my lord.
So, this is a violation of 300A.
I have not received any instruction, my lord.
So, then we direct you to vacate. We believe this is a serious case. There's a kind of a motion. Oh, motion has been issued.
Yes, my lord.
Oh, long time. Every month, every day is a serious date. Infraction to a constitutional right. 300A. Violation. Unhelp it.
My lord, opportunity may be
Land
given to the state.
approximately 6.6 was occupied by AIA from 1996.
1986.
Until date, no compensation has been made to the present petitioner, though the occupation of the said land is already admitted by the concerned. Accordingly, he submitted to the state he be directed to convey survey verification as an interim measure. You are not disputing.
No, my lord, I have not received any instruction, so
Chalo, we ask that person to come.
no, my lord, opportunity may be given to the state to file affidavit, my lord.
We direct the Deputy Commissioner. He has not availed the benefit of having a counsel engaged. You have most probably informed him seeking instructions.
Yes, my lord.
And if the Deputy Commissioner does not feel like that he doesn't want to give instructions to you, it means the Deputy Commissioners think that they don't respect the lawyers whom they are engaging. So we consider them that they don't want the lawyers. And as they don't want the lawyers, we want them to appear before the court. Or we pass ex parte orders against them. So no instruction. This is a case of a violation under 300A.
My lord, for the
Next week.
My lord,
No.
for the interest of
No,
justice, my
Mr.
lord.
Font, next week. Next week this has to be done. We are having it on 2nd of September. Get your instructions from the Deputy Commissioner. I'm not concerned with you. The land is in within the Deputy Commissioner.
Yes, Your Lordship.
Okay. Get an instruction from Deputy Commissioner as to whether the land which is being given to Assam Rifles belongs to the petitioner or not.
Yes, ma'am.
That is the limited instructions I need. If he says no, I will direct for verification and submitting a survey report. If he says yes, then we proceed further.
My lord, let the matter become upon fort.
No.
Trustee, my lord.
If you want, we can have it on Friday.
Trustee.
Friday?
No, date 4.
No,
Next
this
week.
Friday. No, this Friday. Either you accept it on Tuesday or this Friday. 2 dates. Or ask the Deputy Commissioner to be present.
Tuesday.
Yes, very well. The petitioner herein is aggrieved by the action on the part of the respondent authorities in occupation of 6.6 acres of land of the petitioner.
Lordship, 6.61. There's an error in the order, last order.
6.6.
6.61.
6.61.
61. Yes, Your Lordship.
6.61 acres of land. Now, the petitioner herein is aggrieved by the illegal occupation of the Assam Rifles in respect to the land belonging to the petitioner, which measures 6.61 acres. The petitioner herein,
Your Worship, it is not illegal occupation. I have been occupying because
it is his grievance. It is the grievance of the petitioner. I am not saying about you. Grievance. The petitioner herein is aggrieved by the illegal occupation of the respondent Assam Rifles in respect to the land belonging to the petitioner measuring 6.61 acres since 1996.
Lordship, there is an error.
Don't disturb further. I am dictating an order. You are not in a position to say anything. Okay. Leave the matter after 6 weeks.
Much
I
obliged.
was giving you an order, you are disturbing.
My sincere apology, Lordship.
You would have got something. From the Deputy Commissioner, if I could have got it, you could have. I have read the order of Justice Mitali Thakuria. Are you thinking that are you saying that her order is wrong?
Lordship, my sincere apology.
Well, I am asking you, is the order of Justice Mitali Thakuria passed in the month of May 2025 is wrong?
Lordship, my sincere apology.
Then, this is what has been written. I am not writing for myself.
Yes, Your Lordship.
It is written out here that from 1996, 6.61 acres of land. It is not even 6.61. It has been written 6.6. And that is I am saying approximately. Whether it is 6.61 or 6.59 is immaterial. That is your allegation. As to whether Assam Rifles is an occupation or not, that is, they may say. But there is a manner in which I can write an order. And it is not for you to dictate.
My sincere apology,
No.
Lordship.
The counsel appearing on the petitioner while dictating the order has interfered innumerable times, taking into account the above, list the matter before any other bench.
Lordship, my sincere
Much
apology.
obliged.
For Bishop, item number 8.
May I please, Your Lordship?
Yes.
Lordship, I have received my instruction. So if I may become...
Regularization.
Lordship.
Of what regularization?
Lordship,
You have completed 30 years.
Lordship,
Pay scale?
Lordship.
Yes, Lordship. As per instruction, the petitioner is eligible as part of his burden.
I have passed many orders in that regard. If he is eligible, he should be considered, and from the date he has got 30 years.
Lordship.
My orders are to that effect. That means it may be given after 1 year, 2 years, because you have to retire by 35 years in view of the Nagaland area. They may delay, but my orders are very specific that it will be deemed to come into effect from 30 years. the day on which you attain 30 years, because your right to get it attains in terms with the 17/3/2015 on the date when you attain 30 years. So it may take, the steps may require some time. There's no quarrel with that. But it has to be given effect on the date you attain 30 years. So therefore, there are many orders passed by me earlier. Just find out and place it before me. Today, if you can place it, I'll pass the order. I'll ask them to find it out also. Last time I came, many orders I passed. I came in the month of April. Just find out. There are many lawyers who got this.
Come up tomorrow, Lordship.
No. These matters cannot remain for Lordship. You want to dispose of, you want an order. They also say that yes, the petitioner's thing is under consideration.
Lordship.
So therefore, I say that it is under consideration, it will continue. But it has to be given effect from the date on which the petitioner had got 30 years.
Lordship.
So then you get the benefit. Because tomorrow, later on, if sometimes it happens that a person retires, and in the meantime he retires, but the benefit you will get is, because when you retire, your pension is on the basis of your last drawn salary. Now, if this matter goes on and they keep on delaying, the last drawn salary will be on the fixed pay. So your pension amount will come down. But if it is given on the date on which you attain 30 years, then that which is not on a fixed scale, then you get more amounts.
Lordship.
Okay, we'll take it up at just ask them to find out that order, and then we'll take it up. In the meantime, you also try your best to find out.
Lordship.
Okay.
I will.
I oblige, Lordship.
For here, item numbers 9 and 10.
My lord, may I please? My sincere apology. With regard to the previous item, Your Lordship, item number 2.
2?
Yes, admission item number 2, Your Lordship. Lordship,
passed the order now?
Yes, order was already passed, but if a specific time frame may be given, Your Lordship.
Okay.
Otherwise, it will take forever.
Within 3 or 4 months?
Yes, I leave it to the wisdom of the Lord.
I can't do that, but filling up a post, they have to fill it up. I can't give it within a time frame. I have set aside, but it will be within their pay. I cannot direct the state to fill up a post. It would not be proper on the part of this court, because you see, the jurisdiction of this court is only on judicial review. I can't direct. So I can only set aside. So I can't say that within 4 months you do it. I cannot do that. Okay? So that I can't do. You won't do it. Let it remain as it is. Yes, Mr. Longchar. I gave you that report. You saw it. These are fine details being given as to what are the things, the deficiencies out there. The only thing which I am worried out here is this. In my opinion, which I also feel, that when a person dies in the custody, and it is an unnatural death, the principle of res extra locuta would apply. And therefore the state has to give reasons that what due care they had taken, or that there was no negligence on the part of the state. But the fact that a person dies and there seems to be no evidence, even in the inquiry report which had been made by the district judge, she didn't have the original CD or anything to that effect. So therefore, there seems to be certain lapses, for which I think there should be some damages being given, compensation. Yes, madam.
Yes, my lordship. Now, my case is that, Your Lordship, shortly my lordship has already understood the case, everything, but one thing, I have only two submissions, Your Lordship. One is the petitioner has revolved on his case only on the basis of torture being meted out. The torture being meted out to the accused. Your Lordship, yes, I admit that there's a lapses in the CCTV. Your Lordship, because we could not
No,
able to
madam,
actually
when was the inquiry, executive magistrate inquiry done?
Inquiry was done in year 2024, Your Lordship.
No. The person died.
Yes, Your Lordship.
Whether it was done under one, there's a CRPC conviction. When did the person die?
2016,
The date of death?
30.
2013.
No, 2016.
2016. Let us see 176. Where the case is of a nature referred to in clause 1 or 2 or subsection 3 of section 174,
Yes, sir.
where the case involves suicide by a woman within 7 years, where the case relates to death of a woman on a year, the case relates to death of within so and so, 1 and 2 of so and so, this is remand. The nearest they are empowered to hold inquest shall, and in any other case mentioned in subsection 1 of section 174, information that the person had committed suicide or had been killed by another or by any animal or had died in suspicion of self-murder. Nearest they are empowered to hold inquest and unless otherwise directed to any other shall proceed to place where the body was in. Any person who is so important may call them inquiry into the call of the declare instead of or in addition to the investigation held by the police, and if he does so, he shall have all the powers including so and so. The case may be under examination in the court of the data for the body which will be examined to the nearest line out of quality. Now, the person died. That day I gave a particular note. Where is that note? Yesterday there was a note. I asked you to make a photocopy. Day before yesterday I asked a note. There are 2 copies, na? No, one is him. I have given it to him. The other 2 are where? No, there's a signed address. Oh yeah, I got it. It's here. We have to put it on top, no? Okay. Now you see, when was the initial inquiry held? The first inquiry.
Initial inquiry is on 16/11/2016.
Mr. Longshore, where is the list of dates? Any list of dates? He died on Iman to a parent that his late brother so and so year on the night of so and so. 28/10/2016. So he died on 28/10/2016.
He was arrested on 29. He committed suicide on 30.
Okay. He committed suicide.
On 30 morning.
No, died on 29/10.
No.
Are you sure?
Yes, I'm sure.
Where is his death certificate?
I think it's also abroad in the petition.
Right.
My learned friend is trying to impute the law against the petitioner. The petitioner was totally not innocent. Only on the dead body.
Now, Mr. Longshore, where is the inquiry report made on the 176?
With everything of position of respondent in WPC 216.
Annexure 4. Annexure 4 to the affidavit.
It appears on the same day, 30th and 16th.
Now, where is the cloth? The cloth where he was hanged.
Yes, Your Lordship.
Where is that? It is not there in the minister's report. There seems to be something funny or fussy. Something is wrong because of the fact that where is that particular cloth? Somebody says it to be a pillow cover. Somebody says to be a bed sheet. There's nothing even in the ministry. This is also a very perfunctory manner by which the extra assistant commissioner has conducted. The magistrates, what is the nature of this inquiry in terms of 174, 76? Where in the nature of so-and-so the magistrates have hold an inquiry into the cause of death, either instead of or in addition to the investigation held by the police officer, and if it doesn't so, he shall have all the powers of conducting and so-and-so. And this magistrate inquiry report is given on 10/11 email. This is just for the sake of giving. Conducting inquest investigation, the following are found. Multiple so-and-so, the right eye socket. This is, he is giving a postmortem report. Isn't it, madam?
As per the.
Can you see Annexure page 27?
Yes, I got it.
Annexure.
Yes,
It is like a postmortem report. Let us see what was seized, the seizure memo.
Your Lordship,
Any
that-
seizure list prepared?
No, that is actually not there, Your Lordship. That is PC, Your Lordship.
Seizure list? And you, Mr. Longchar, your client is the brother?
Yes.
Yes, Miss Livika, what do you have to say?
Yes, Your Lordship, my only.
I could have done it, finished it there in Gauhati.
Yes, Your
But I thought that doing it here would be better.
Yes, Your Lordship.
Because otherwise video conferencing, it may not be clear.
Appreciate Your Lordship. Appreciate your concern, Your Lordship. Your Lordship, the thing is that my only thing is that yes, there are some lapses we have actually as discussed, Your Lordship, but we can see on the post-mortem also that to substantiate that there was no torture being meted out. Because
No, it's not a question of torture. The torture is, they have not even looked into it. The magistrate inquiry doesn't say anything as to whether they say there's a right eye socket was blue.
yes, that was because, Your Lordship, he was being abused by the public also.
Now,
When he was
no.
taken, Your
Therefore,
Lordship. And-
at the time when you are arresting,
Yes, Your Lordship.
you have to take him to the hospital.
Yes, there's a medical evidence, Your
Where
Lordship.
is that report? Prior to his arrest?
Prior to, right after his arrest, Your Lordship, he was sent for medical treatment. Your
Yes, where is that?
Your Lordship,
Here, page 14.
yes, Your Lordship.
You say swelling,
Yes, Your Lordship.
you say swelling, right, it's not understandable. Abrasion, armpit, eyelid, abrasion. Swelling, where?
On the lower eyelid.
Swelling.
Yes, Your
Lower eyelid.
Yes.
Abrasion. What is this abrasion where? Armpit. Okay, we'll take it up. I have a video conferencing matter at 2 from the principal seat.
Yes, sir.
After that, we'll take up that another matter, then we'll take up.
Okay, ma'am.
For orders, item number 1.
Yes, Mr. Gogoi, did you find any solution to the problem?
I have already sent it to the.
I can't hear you. Can you make it a bit louder? We can't hear you.
I have already sent the documents to the bank.
No, Mr. Where is the computer people out there? There's no computer people. We don't have the computer people here. We can't hear anything today. There was another lady who was arguing the matter. It's a matter of urgent necessity.
Hello, check. Am I audible? Hello.
Nobody can hear anything. This is not working. Call the computer people. Call up those persons from the principal to the principal seat. Tell them we can't hear anybody. We'll have the matter at 3 o'clock. In the meantime, I'll get these people done. Where's the computer person? Yes, we can't hear anybody from there. Well, what's wrong? Call up those persons, your counterparts in Gauhati, and find out what is the problem. This is a matter of urgent necessity. Why we can't hear anybody? Yes, Mr. Gogoi, can you speak? Yes, Mr. Gogoi, I can hear you a bit. But the voice is very feeble.
Already I have.
I think the problem must be here. Yes. Yes, Mr. Gogoi. Make your submission.
Send it to me.
How much you are doing? What are you doing now?
How much it's 5 crore. Now it's in respect of 5 losses. And see it is 5 crores losses in respect of other changes losses. And as per my lot's direction, half date is finance to losses 6/8 losses 6/9/25.
6/9, na?
9/25 losses up to 3 p.m. That's why my lot's direction.
So now you are making it at last 3 years 5 crores.
5 crores losses, 5 crores. 5 crores. That requirement is quite otherwise some difficulty there also.
Can you do one thing? Can you put a short affidavit?
Yes.
Then why you have put it at 5 crores?
Okay.
Can you do it on the...
Worship sound is not come.
Can you hear me?
Yes.
I'm saying that if you can make it 5 crores, you are making it for 5 crores for the last 3 years annual average turnover.
Yes.
Then in that regard, provide the reasons why you want this 5 crores as annual average turnover for micro. because the small always is there. Small has no problem because earlier it was 10 crores, now it has become 50 or 100.
100
So, 100. So there's no problem with the small. The small is always there. So only the question is of the micro. So if you are making it 5 crores, yes.
Micro is as per the latest amendment, 10 crores.
Understood. But you are asking the last 3 years, na?
Last 3 years.
Yeah, last 3 years, if it is, it means those people are out.
Last 3 years.
So therefore, if you are asking for last 3 years, you can have it at 5 crores. There's no quarrel with that. But just give the reasons. There might be various reasons. Just for example, there might be a reason that taking into the quantity of supply which is required to be made. So therefore, this is the reason why.
Exactly that part, as per Manus direction, there was a dispute between the officers and ours lawsuit, between us lawsuit.
So you just put it on affidavit so that I can also and bring that corrigendum on record by way of test.
I'll do that.
We'll have it on Friday at 2 p.m. if it is not problem.
Lordship. Even Monday also, Lordship, Monday, if required, Monday, Lordship.
Monday, it's okay, but Monday wouldn't it be too long because you will say having it on 6th, nah? The last day.
I'll Friday, Lordship, Friday. I'll do.
Tomorrow or day after in the morning, we have it at 2 p.m. But in the meantime, you need to send a copy of that to me to this court.
Lordship, I'll do, Lordship, I'll do.
File it and I'll ask there. Mr. K. Gogoi, the learned additional senior government advocate submits that the respondents pursuant to orders being passed by this court have taken a decision to extend the last date for submission of the technical bid to 6/9/2025. He further submitted that in respect to the micro industries, the respondents have also decided to lower the annual average 3 years turnover to 5 crores. Full stop. It is the opinion of this court that the same be brought on record as well as the reasons for taking such a decision by way of an affidavit. List this taking into account that the matter requires an urgent disposal, list this matter again on Friday. Put the date on Friday at 2 p.m. The matter will be taken up through the video conferencing mode. The registry of both the principal seat as well as the Kohima bench shall ensure that the connection is proper so that there is no interference while conducting the hearing.
Lordship.
This one, 5 crores. So as 5 crores for micro, small and medium enterprise, huh? Not for micro. You are giving it for all, huh? All the 3.
Lordship, here reflected all the 3, Lordship.
Okay, for micro, small and medium enterprise. Huh? Sure. So you bring it on record. By tomorrow you file the short affidavit and then we'll take it up.
Lordship.
Where is the other matter we have taken up now? There's another matter. Yes, your matter. Where is that lady gone? Yes, I told you now I passed an order on it.
Yes, Lordship,
There is a WBC number 309.
Lordship.
Ah, I got it. I think this is an order which would be helpful for you.
Very much, Lordship.
So we pass a similar order to that effect.
Lordship.
Where is your counterpart?
She was here before. 8.
See, I'm making a call.
Okay, sure. Let me start dictating. Madam, this paragraph 1 and 2 remains the same. Paragraph 3, huh? The case of the petitioner in brief is that by an office order dated there are how many petitioners? Two petitioners, Lordship. Here there will be petitioners, in this order. In the instant with petition, there are two petitioners who seek, paragraph 2, appropriate directions for compliance to the office memorandum dated 17/3/2015, inasmuch as the petitioners duly claim that they are eligible as per the said office memorandum for their services to be regularized. It is the case of the petitioner number 1 that he was appointed as work charge labor fixed pay on 2/8/1989 under the establishment of the Executive Engineer PHED, Kohima, Rural Division, and subsequently by an office order dated 15/10/2020, he was promoted to W/C Khalasi in the scale of pay of rupees 3,000-15,200 per month with effect from 1/1/2020. The petitioner number 1 was also issued a WC IT card dated 6/2/2021. The petitioner number 1 was served for a period of 35 years and was released from service with effect from 31/8/2024. It is the case of the petitioner that the petitioner, in terms with the office memorandum dated 17/3/2015, the petitioner completed 30 years on when?
Zero 02/08/2019.
No, it cannot be 02.
Lordship, page 17.
It would be on 02/08/2019.
Lordship.
Next. The petitioner number 2 was appointed as work charge labor on 21/12/1986 under the establishment of the Executive Engineer PhD, Kohima Rural Division, and he was promoted to the post of controlman in the scale of pay with effect from 21/3/2000. The petitioner on completion of 35 years of service, was released on 7/1/2022 with effect from 31/12/2021. Isn't it?
Lordship.
Full stop. It is the case of the petitioners that the petitioner number 2 completed 30 years on 21/12/2016. Isn't it?
Lordship.
The case of the petitioners, therefore, as would appear from the materials on record, is that the petitioners are entitled to, the petitioners ought to have been regularized in terms with the office memorandum dated 17/3/2015 on 2/8/2019 insofar as the petitioner number 1 is concerned, and on 21/12/2016 insofar as the petitioner number 2 is concerned. However, as the same was not done, the petitioner has approached this court by filing the instant writ petition. Full stop. It is seen that this court, by an order dated 21/7/2025, issued notice and directed the government advocate to get instructions as to whether the case of the petitioner can be considered in terms with the office memorandum dated 17/3/2015, and an effort shall be 15. Full stop. Ms. So-and-so, appearing on behalf of the respondents, have placed before this court certain instructions.
Lordship, actually, this is a para-wise comments.
Have placed before this court the para-wise comments received from the chief engineer and HOD PhD Nagaland, wherein it has been mentioned that the proposal for regularization and absorptions of the petitioners along with similarly situated employees were submitted to the government by letter dated 19/4/2021, wherein the name of the petitioner number 1 was reflected as serial number 14, and the name of the petitioner number 2 was reflected at serial number 20 under the Kohima Rural Division. It has been further mentioned that the said file, that upon proposals being duly submitted, the P&AR department on 14/2/2022 conveyed their clearance in respect to the petitioner number 1, and in respect to the petitioner number 2, the clearance from the P&AR department came on 4/8/2022. It was further mentioned that the files were thereafter forwarded to the finance department for clearance. However, on 24/1/2023, the file was returned back to the respondent department with a direction seeking certain compliance. Further to that, it was mentioned that the regularization in terms of the office memorandum dated 17/3/2015 requires various clearance from various departments, and as such, the same is time consuming. And as such, it is not same, it's time, and as such, there would be requirement that as such, further time would be required for providing further for regularizing the services of the petitioner so that they are entitled to the benefits. Full stop. The instructions which have been submitted is kept on record and marked with the letter X. Full stop. Then, madam, from here, in this judgment which I have put out there, 309/2000, paragraph 6, have perused the pleadings as well as the instructions kept on record. And taken note of the respective sign from the purpose of deciding so and so, this book, there are 6, 7, 8, 9. Taking into account 9 paragraph, taking into account that the petitioner number 1 had completed 30 years of service as on, what is the date? What is the date of petition number 1? 08/2019.
Lordship.
And the petitioner number 2
21/12/2016.
on
21/12/2016.
12/2016.
Lordship.
And was on the scale of the petitioner's rights to be regularized with a rise. Now the petitioner number 1 and petitioner number 2 rights to be regularized with a rise on 02/08/2019 and 21 21/12/2016 respectively. Which is a deeper fact which will be seen from the what is the name of petitioner number 1?
Hanankat.
Huh?
Hanankat.
Ananka. Very good. Ananta.
Lordship.
Okay. Seen from the list enclosed from the list dated from the list from annexure A to the list the communication between petition dated 19/4/2021. Hello, this I have corrected it, huh? Dispose.
I like
For written, item number 5.
Yes, madam. Here the issue is this. The petitioner herein have assailed the order of the respondent number 3.
Yes,
Now the respondent number 3 in the meantime have retired.
Lordship.
So therefore there is a vacancy which have arisen.
Lordship.
Now whether the petitioner knows or not, or wants to claim as per land ownership, let her put up the application. And as it is a case of an oral agreement, let the deputy commissioner look into it in terms of 3B.
Lordship, here the position is like someone from the client has already availed the opportunity on the basis of land ownership.
They have already got
Yes,
it?
yes.
Where is
So
that statement?
That, Your Lordship, I have already filed my affidavit.
No, in the affidavit that mention is not there.
Is there,
That
Your
it
Lordship?
is from the petitioner's family.
No, Your Lordship, I have filed 2 affidavits, one in reply to the repetition and another in reply to the rejoinder filed by the petitioner. So in the rejoinder affidavit, Your Lordship may kindly come to para 3. I have filed it on 19th of August.
is the name of the petitioner?
Petitioner is Chitala.
Chitulu Venu.
Yes, Lordship.
Chitulu Venu.
So, Your Lordship, they are the descendant of Sauvina. If Your Lordship may kindly...
Daughter of Nityuhahu Venu. Nityuhalu Venu is the petitioner's father.
Yes, yes.
Who is the brother of the wife
Luvezo Vina.
So who is the elder brother.
Yes.
So he's the petitioner is aunt.
Yes, yes.
Aunt was appointed.
Appointed.
Who is the aunt?
Who is the wife
the
of?
relation is the petitioner's father's
brother's wife. Yes.
Isn't it?
Yes,
Petitioner's
yes.
father's
Brother's wife. Yes.
On land ownership.
Yes, Your Lordship. So Your Lordship may kindly come to Annexure E. There are 5 landowners. Annexure E, page 13.
This is being done
by the head DB on the direction of the DC.
While inviting a reference to a subject cited and in response to your order dated so and so, I am bound to submit the re-verification for land ownership certificate. A team of DB had re-verified on month authentication of the land ownership. Whereas on intensive and thorough re-verification, it was ascertained that the land on which the deputy commissioner text is a joint ownership of 5 descendants as mentioned. So if any, father of
Luvezo
Venu and Nityo Venu.
Yes.
So their petitioner's grandfather
Yes.
donated the land.
Yes. That is not disputed.
And the petitioner's uncle, wife got the job.
Appointment. Yes.
Lordship, that was solely on political appointment.
Huh?
That was solely on political appointment.
No.
Here,
Political appointment?
Yes,
What is the
Lordship.
concept of political appointment?
In fact, the
The
petition...
document is very clear, Lordship. If Lordship may kindly come to page number 8 in Annexure B, filed by the filed by the state respondent.
Okay, affidavit.
Yes, the one that I received this morning.
For post of peon.
Yes.
On having learned that a post of peon is lying vacant under the air vacancy which was caused on retirement of so and so, to offer myself as a local and Igata landowner first, as also as a landowner.
Lordship, this was appointed only on the recommendation of the Minister of Rural Development, Kohima.
We appoint her as peon on priority.
It's very clear,
Landowner
Lordship.
certificate has been given. This appointment which is being given to your auntie, aunt is on the basis of land ownership.
Yes.
This is clear from page 8.
Lordship, she was appointed only on the date of her late husband on compassionate and political
But
ground,
this is not
Lordship.
the basis on which it has happened. This is being a genuine case on land ownership.
Yes.
I strongly recommend so and so for the post of peon in the office of women as she is the bona fide landowner. Then, what is left?
So, Your Lordship, out of 5 landowners, there are 3 landowners still yet to avail the opportunities. So, even if the vacancy falls, Your Lordship, it cannot be in perpetuity.
Lordship, is very clear that the Deputy Commissioner has also acknowledged that I'm one of the landowner.
Yes, DC is acknowledging that they are the descendant of the...
Yeah, there is no quarrel, but you have got it. You got one job.
Yes.
So 3C will apply.
Yes.
Isn't it?
Yes.
Lordship, in that case, a short date may be fixed so that I can consult.
I think best of these you withdraw. The reason is
Lordship,
if
short
I
time may be
say
given.
that you are not entitled to, you give them a handle for land ownership. And the next appointment will be made on land ownership.
Lordship, in that case, a short date may be given.
Tomorrow?
A short date may be given.
Short date is tomorrow.
Friday, Lordship.
You only obtain instruction as to whether this affidavit was filed on 19th, long time back. Ask your
I received
client
only this morning, Lordship.
Friday. Friday we have to finish this off.
Your Lordship, Friday I have some personal difficulties.
I
Let it be.
record that you are already present.
Lordship, I'm grateful.
I've come to learn from this. There's nothing.
Lordship, grateful Lordship.
It's only a question of dismissal.
Yeah.
And your good friend, where is Miss Libika? She will appear and say
Lordship,
on your behalf.
Grateful.
And we will show it as a representation as Miss Mayor.
Lordship, grateful Lordship.
Lordship.
Is the matter again on having been heard at length, the learned counsel appearing on behalf of the petitioner submits that she would obtain instruction in respect to the affidavit in reply filed by the filed by the respondents on 19/8/2025 is accordingly on file.
Grateful.
Much obliged.
For hearing, item number 9 and 10.
So, Ms. Livika, the court case, that there are two reasons why it needs to be done. Because of the first that there has been a lot of infraction to the rights. 174, 176 inquiry was not in a manner in which it should have been. There is no even, you have not seized the plot by which the person committed suicide also. All these things show that it has not been done properly. So there are grave suspicions that the person must have done this, for which we hold that there has been certain negligence or there is a constitutional tort. And I think why I am saying so is this is a matter where certain guidelines have to be laid as to how you need to perform. And then impose damages to the tune of how much? 2 lakhs, 5 lakhs, 5 lakhs?
Lordship, so in that regard, I also have one submission, Your Lordship. But firstly, let my submission be also recorded as far as the torture is concerned, because my concern is, Your Lordship, if my submission can be recorded, Your Lordship.
Yes, you do one thing.
Yes, Your
I won't dictate it right now.
Yes, Your Lordship.
You give a short written submission.
Okay.
And incorporate everything.
My submission,
Yeah.
okay, Your Lordship.
And Mr. Longshaw, you also.
And Your Lordship, meantime, it is, I heard that the petitioner, maybe my senior counsel might not have been aware of it, but the petitioner, they have already filed before the human rights for civil compensation. Now we are talking about civil liability, Your Lordship. Now they have filed before the commission.
Instructions?
And last night only I got a copy.
Your written submission?
No, not my written submission. I got a copy that
yes.
they have already filed before the human rights. Human rights has commissioned 5 lakhs, Your Lordship.
Is it?
Yes, Your Lordship, and that is not being aware, Your Lordship.
Then I don't think we should allow anything.
So this
Note application, Mano. Note application. I'm not aware of it.
yeah, my counsel might not be aware, but
No, you may not be aware. You take your instructions.
Yes.
On this. Maybe they have it. They have, while this matter, Chief Secretary complained in I am directed to say that the matter was considered by the Commission and the Commission has directed the incident matter pertains to so and so. Lukamuddin, son of Azumiya, so and so regarding death of his brother, namely Jalaluddin in the year. Now, who has approached here? Ansar Ali is who?
Ansar Ali is the father, I think. And Lukmanuddin is the brother, Your Lordship. He's the one who has filed FIR in Assam.
Lukmanuddin is the brother.
Yes, Your
Who
Lordship.
is Ansar Ali?
Ansar Ali is the father.
The elder brother. The elder brother of the deceased.
No, who is
Jalaluddin.
Lukamuddin?
Lukmanuddin is also a brother.
He is also a brother, so he could have approached. That's a possibility. Since that is the first information I'm getting.
Your Lordship, if I'm not mistaken,
Commission by its proceeding to a directed commission office on protection of and to why the commission should not recommend payment of the fee. Subsequent the commission by the proceedings and admission demand and final no other reply of the commission is allowed to proceed. Now, have you paid these 5 lakhs?
Yes, Your Lordship. Only last night I could I got an information. That's why I traced the document.
Now, have
last
you paid
night
the
only.
5 lakhs?
That's why, Your Lordship,
Now,
there is
if
an
you have
intimation.
paid the 5 lakhs, then I would not take the trouble into
Yes.
going into further.
That's why I have to inquire on this. That's
No,
why only last night.
No, you let us know
Yes,
as to
Your
whether the 5 lakhs have been paid or not.
Yes, Your Lordship. Yes, Your Lordship. I will make an inquiry because
Because this order was passed in the year 2024.
24 last month.
We are in the almost nearing 1 year.
Yes, Your Lordship.
Have you paid or not?
That
Just
is the
find
thing.
out. If you have not paid, then I'll do one thing.
Yes, Your Lordship.
I will issue this, whatever may be, I'll issue a writ for payment of this amount of 5 lakhs, taking that you have accepted this. You see, Miss Divika, you have to understand, the moment you are showing me this, means you are accepting.
Yes,
See, this has an implication. The moment you are showing this, you are accepting the 5 lakhs.
The reason why I am also showing this thing before Your Lordship is because there should not be two
Not only,
proceedings
two,
also.
because this is the matter. They must have got tired
Yes, Your
of this judge who have been hearing this matter for a long time, and maybe therefore they have approached the Human Rights Commission, and the Human Rights has given these 5 lakhs and all.
So maybe
Now, therefore, the moment you are accepting this, it would be deemed that you have accepted the compensation.
So, Your Lordship, there is a letter to the DGP also, and I am yet to know on this whether payment has been made or not.
No, if the payment has not been made,
that's why, Your Lordship.
if the payment has not been made, because you are relying on this, then I'll pass direction for making payments, and then to ensure compliance and to file an affidavit of compliance before this court.
Your Lordship, so
Mr.
Your Lordship.
Longshore, I think then it would be okay, I suppose.
Well, since we are coming on a civil liability, Your Lordship, so let me inquire, Your Lordship, whether any payment has been made or not in
Monday?
this regard. Yes, Your Lordship.
I need to finish up before
Yes,
I
Your
leave.
Lordship, this we have to finish. We are so tired.
I need to finish up before I leave, because I've given a lot of thought about this matter. I've gone into matter a long time, but normally I don't take so much of time in looking into this. But this has a lot of ramifications out there, because this is an order by which I could have very well laid down the guidelines in what is to be done and there appears to be apparent negligence on the part of the magistrate. Apparent negligence in the manner in which he has performed his duty under 176. He has made it as if it is like a postmortem, isn't it? There has been no seizure of the cloth. One person says, one witness says that it is a pillow cover. The other says it is a bed sheet. And that bed sheet or the pillow cover is not a seizure document.
Neither one was that.
The person concerned is of the height of 5'10", and the person from where it has been tied is 6. And a person, when he gets with his feet elongated, it becomes more than 6. So where is the question of him being tied out there? All these factors are there, I've looked into. But if you are saying that this is the amount and you are ready to pay, you are ready to pay.
No, Your Lordship, there is a direction by the Commission. The Commission has written a letter to the
Commission is
city.
different, Mr.
Yes, Your.
I think you have to understand. The Human Rights Commission is an authority
Yes, Your Lordship.
which is made under the Act.
Yes, Your Lordship.
And that direction, how they are going to comply is another aspect.
Yes, Your Lordship.
But I can put the teeth to that order by an order being passed by this court and file an affidavit of compliance before this court within a particular time.
So, Your Lordship, let me just seek a direction, because
Monday.
even this document, Your Lordship, I could able to get it last night only. So I'll make it
If
Tuesday, Your Lordship.
you only explain it to your person concerned, or if those person concerned wants to see the video, they can very well see the video and tell them. If they pay this amount or ready to pay this amount, they would not invite various observations which this court otherwise intends to put. So therefore, they should be prepared to make the payment.
So, Your Lordship, let me just inquire. Tuesday, Your Lordship.
Monday.
Tuesday, Your Lordship.
No,
Because
Tuesday is not a good day. Miss Lipika, the Learned Council appearing on behalf of the government submits that in the meantime, during the pendency of the repetition, one of the brothers of the deceased had approached the National Human Rights Commission, wherein there was a direction for payment of an amount of rupees 5 lakhs as compensation. The Learned Council therefore submits that in view of such directions by the National Human Rights Commission, the instant proceedings may not be further proceeded with, taking into account that in respect to the same cause of action there cannot be different avenues. There cannot be duplication of proceedings. This court inquired with Ms. Livika as to whether the order dated 30/10/2024 issued by the Human Rights Commission have yet been complied with or not, taking into account that almost 9 months have all elapsed. 11 months. 10 months have already elapsed.
The matter was to be listed after 8 weeks before the commission. So
This was given on 30/10.
Yes, if we see the order, Your Lordship. List the matter after 8 weeks. So, Your Lordship, I just have to inquire into the matter.
The order is of 30/10.
Yes, the order is of.
Almost 10 months have elapsed. Ms. Livika submits that she will obtain instructions in that regard. This is the matter on 1/9/2025 for further hearing.
Much obliged.
For hearing item number 12.
Yes, what is this, Mr. Iralu?
Yes, in this matter, the petitioner is aggrieved with a show cause notice, whereby the petitioner is aggrieved with a show cause notice.
Show cause notice?
Yes, whereby it has been proposed to terminate the petitioner without holding any
Show cause
disciplinary
notice, why
proceedings.
should we interfere?
It has been proposed to terminate him.
So
By
you
the
will
show
let
cause
them
notice.
terminate, you come, there's an appellate forum.
No, prior to that, they have sought an explanation. They have sought an explanation. Now, in
Now,
response
what
to
are you
the,
challenging, let me see.
the show cause, yes.
Show cause notice set aside, the show cause notice dated 2/4. So and so is not
2nd
contrary.
April.
It has been noticed that throughout your career you have warned several times for performing your work under the influence of NI and also related to. However, there is a serious apprehension that someday, upon a certain made on here, you are able to so cause by your service. No. This person is a worker, na? So they cannot go for termination. Well, the so cause you have already issued a so cause notice. But you have to, are they not protected under the 67 rules that there has to be an inquiry?
Yes.
Under Rule 9?
Yes.
That's your case?
Yes. That is it.
See? Reading this only I came to know.
Lordship, if I can make a short submission on this, I know I have a very weak case.
Nobody, you see, keeping the matter pending doesn't happen. Question of setting aside this doesn't happen.
Yes.
What is required is that there is to be a direction being given.
Yes.
It is like a river being blocked by stones. We just need to open it, and so that you can go ahead and have an inquiry, isn't it?
That's a different way to put it. Yes. If you want to proceed with the proceedings, then proceed as per the
proceed
law.
in terms with the
Yes,
rule line.
that's it.
Yes.
That's all.
That's
Yes.
it, that's it.
Why, but if you get a stay and keeping this pending, is not helping the work.
No. That I agree. That I
And
absolutely
he's
agree.
also under suspension, I suppose.
No.
Working also.
He is not under suspension. Your Lordship, in fact, my only submission will be this. As far as the disciplinary proceedings is concerned, yes, without proceeding, having a disciplinary proceedings, going to a show cause, that is wrong. However, Your Lordship, the entire concept of the disciplinary proceedings is to prove the evidence, is to prove that the offense has been committed by the accused government servant.
Let's see, Rule 9.
Yes, Your Lordship. That I agree. I absolutely agree with my Lord.
One provision out there. No, when he files a reply, he has given an explanation. Wherein you admit it
I believe he has acknowledged.
Yes, he has admitted it.
No, initially, this is done under the CCS.
No, under the Nagaland
Disciplinary
Discipline and
Appeal.
Appeal rules.
Okay, where is that rules?
I have enclosed that as an annexure in my petition. Starting from page 27. Rule 9 is at page 33.
So if you can come under 11.2.
Yes.
But you have to consult the commission. You cannot take like that. You have to consult the commission.
Lordship, of course, Rule 9.1 also is clear that any action before it is taken.
Well, you have to do it because there are a person may admit many things. That
Yes.
might be your document.
Yes, yes. So, Your Lordship, yes, quashing and setting aside the impugn order, that I agree, Your Lordship. But liberty may be given to the department to initiate proper proceedings.
Mr. Irando will be happy.
Yes.
He doesn't want to only. Mr. Irando will be getting less fees coming here. So he will go in other places also.
If that liberty is granted, Your Lordship, I have got no objection, my Lord.
No, that is it.
Yes, that's it.
Heard Mr. I.L. Iralu, the learned counsel, appearing on behalf of the petitioner, and Mr. N. Angami, the learned counsel, appearing on behalf of the respondent. The petitioner herein have assailed the show cause notice dated 2/4/2024, whereby steps were taken by the General Manager, Nagaland State Transport, to terminate the petitioner merely by issuing a show cause notice and not following the mandate of Rule 9 of the
Nagaland Discipline.
Nagaland Service Discipline and Appeal Rules 1967. This court heard Mr. N. Angami, the learned counsel, appearing on behalf of the petitioner, and inquired as to whether the Nagaland Service Discipline and Appeal Rules 1967 would be applicable insofar as the Nagaland State Transport is concerned. The learned counsel, appearing on behalf of the respondent, submits that the said rules of Agote rules of 1967, the said rules of 1967 would duly apply. This court further takes note of that, taking into account that the petitioner herein would have been appointed to a government service, he is protected under Article 311(2), isn't it?
11.2, yes.
11(2) of the Constitution of India. And further, in terms with Rule 9 of the Rules of 1967, read with Rule 10, which relates to major penalties, it is the opinion of this court that without making an inquiry, reading Rule 7, Rule 7, 7(9), Roman 9. Rule 7(9), Rule 9, read with Rule 7(9), Roman 9, and Rule 10. It is the opinion of this court that if the respondent authorities wishes to impose, deems it proper to impose the penalty, a major penalty, the penalty of dismissal from service, the respondents have to resort to the procedure as mandated in Rule 9, or have to take action in terms with Rule 11 No, Rule 9. Let us put it Rule 9. Don't make it complicated. Rule 9. Of the rules of 1967. Accordingly, in that view of the matter, it is the opinion of this court that on the basis of the show cause notice dated 2/4/2024, the petitioner cannot be terminated. First, the termination cannot be dismissed from service. Accordingly, this court disposes of the instant writ petition with the following observations and directions. The communication dated the show cause notice dated 2/4/2024 cannot be the sole basis on which the petitioner can be terminated. Number 2, the petitioner, if the respondent authorities deems it proper to impose certain penalties upon the petitioner and further as to penalties and most penalties upon the petitioner, and that too a penalty in the nature of dismissal from service, the petitioner being a protected employee in terms with Article 311 bracket 2 of the Constitution of India, resort has to be taken in terms with Rule 9 of the rules of 1967. Number 3, this court observes that the show cause notice dated 2/4/2024 shall be deemed to be a show cause notice as to why discipline. Accordingly, number 3, this court grants, while interfering with the show cause notice, therefore, while interfering with the show cause notice dated 2/4/2024, grants the liberty to the petitioner, respondents, to initiate proceedings under Rule 9 of the rules of 1967, if so advised.
Lordship.
Deeply
Deeply obliged.
Interim orders passed the list and speaking.
For hearing, item number 4.
Please, Lordship.
Yes.
Lordship, here in this case, there are 5 petitioners.
This is the last item? Last item of the day?
No, Lordship.
Last item.
Oh, good. Now what is this item?
Lordship,
regularization.
Yes, Lordship.
17.3.
Yes, Lordship.
17.3/2015.
Yes, Lordship.
Then, how many petitioners?
5 petitioners, Lordship.
Oh, this is bad. Why are you filing so many petitioners? One petitioner. Very difficult.
Here, they state in their affidavit, paragraph 6, they have clearly stated that they have forwarded the names of the petitioner to the government for regularization.
What?
In paragraph 6 of their affidavit, they have clearly stated that they have forwarded the names of the petitioner
for
to the government for
regularization.
regularization. Yes, Lordship.
Madam, we passed that order.
Later dated 17/3/2025.
This order, where is that? That order which was there, I passed similar order. You regularized within
Yes,
6
Lordship,
months.
it's under process, yes, Lordship. They've completed 30 years.
But their regularization shall date back to the date on which they complete 30 years. Okay?
Yes, Lordship.
It was if order, I passed an order. I think many have taken one. I think we can dispose of this one also. But this will have the similar trappings as the earlier order which I had passed. Khaliya told there are 5 petitioners, so there will be different dates. Is it the same date of appointment? No, na?
Lordship, they are serving in
all different.
Same department. But
no, same date of appointment.
No, Lordship. I've stated in my page 10.
It is appointed, 1 appointed, 2 appointed, yeah. So there will be different dates.
Yes, Lordship.
So therefore, we have to give a chart. Let us try how my stenographers are able to cope up and do it, because I have disposed of one today. So here the difference is there is already an affidavit that the petitioner's case are under consideration.
Yes, Your Lordship.
So therefore there is no denial that they are not entitled to. But the fact that there would be delay, taking into account that there are 4 departments from which clearance is required. So this court will duly observe that and thereupon say that you do it within a period of 6 months,
Yes, Your Lordship.
preferably. But when you give him, you have to give him from the date on which he completed 30 years. 30 years when he is completed. You have to give the dates, na?
Yes, Lordship.
Petitioner number 1, Likilo Bosun.
Petitioner
number 1 complete 30 years in 2014. Is it?
Petitioner number 1, he was released from 2018, 31/10/2018.
Huh?
He was released on attaining the age of 35 years.
When?
On 31/10/2018, petitioner number 1. He was released from the service on 31/10/2018 on attaining the age of 35 years. And petitioner number 2, he was released on 31/5/2018 on completion of 60 years of age. Petitioner number 1, 3, and 5 was released on completion on attaining the age of 35, and petitioner number 2 and 4 was released on completion of 60 years of age.
When was the petition and all the release orders are here?
Yes, Lordship.
So, on this post.
Lordship, I have a very humble prayer, Lordship. Since the letter was forwarded to the government on 17/3/2025 and 5 months has already been lapsed. So, Lordship, if this court may also consider the 5 months lapses, well, passing the order, Lordship.
Mr. Counsel, let me tell you one thing. This petitioner left job in 2018.
Yes, Lordship.
Where is your representation given that you have not approached? Let us now also be very technical. Huh? If you have not represented before the authorities, can I issue a mandamus? Tell me. Let this also be. So let us maintain a.
Lordship.
Huh? Yes, yes. Dispose, huh?
Mary, item number 4.
Much obliged, Lordship.
Lordship, here the impugned letter or the direction is at page 22. In questioning the jurisdiction of the SDO who issued this direction.
Violation Nagaland food security
Yes.
rules. What have they?
Under the NFS rules, it has to be the ADC who is
14/3/2000 set aside the letter dated 9/9. What are you challenging? Let us see 14/3.
yes, this no 22, page 22.
14/3. Where page?
22.
20?
22. 22.
Regarding misappropriation to be released with reference to the amendment as per the variation from the area and so regarding misappropriation it has been reported that the lot area has not been distributed in intent. I am directed to inform you to return the rights back to the allotted beneficiary through DISCO as per their entitlement within 1 month. Okay, then?
Now, this under the Nagaland Food Security Rules, the ADC,
Who has filed this?
the petition.
Then this is given to somebody else.
No, this is the petitioner, to the petitioner. He is serving as a council chairman, he is council chairman of the
It has been given. There is a case of misappropriation.
Yes.
Then what else are we challenging here?
This direction I'm challenging on the ground that the SDO lacks the jurisdiction under
Set
the
aside the
Nagaland
impugn order dated 14/3/2024. Where is that?
The impugn order. My apologies. 21, page 21, page 21.
21. With reference to the complaint received from the members of the so-and-so regarding mismanagement of so-and-so and directed by the Deputy Commissioner to hold inquiry, the concerned complainant and the BCCI is hereby directed to be present with all relevant documents. No other member of the village will be allowed. The concerned complainant and the VCC, village chairman.
Village council chairman.
You have been asked to appear.
Yes, I appeared.
So?
And then
why you are challenging this?
On the ground that the SDO lacks the jurisdiction under the Nagaland Food Security Rules.
Who has the jurisdiction?
The ADC. The ADC, Additional Deputy Commissioner. For any queries or grievance related to misappropriation of the rice, which are disputed under the scheme, the
What did
Nagaland.
they say? So you are challenging on the question of jurisdiction.
On the question of jurisdiction only. At page 23, I've enclosed the rules.
So what is your stand? Do you stand?
Come again, Your Lordship.
Mr. Angame, where is the now that is done. But what has the Deputy Commissioner taken any action pursuant to this report on 34/2024?
Lordship, yes, which is impugned here. Which is impugned here. Has been the.
I don't think they have impugned the 34/2024 report, which is the last annexure to your affidavit.
No, they are not. They are not impugning this report.
So, what action have you taken pursuant to this?
Your Lordship, pursuant to this report, the
subsequent
the
direction
subsequent
was issued. The impugn direction was issued.
Yes.
September direction was issued at annexure 2, page 22.
Okay. So 9/9 impugn order has been stayed.
Yes.
On 4/10.
Yes.
So
Yes.
prior to that, 4/10/2024. No, but they have already submitted the report on 34. So, where is the impugn order of 9/9? 99 was passed subsequently.
Yes,
But
page-
prior to that, we have already submitted a report on 34. Now, therefore, you
Yes.
see what it appears.
Lordship.
There was a complaint made
Yes.
that some beneficiary did not get the rights.
Correct.
Against that, you say in your affidavit the Deputy Commissioner instructed the SDO to look into it.
Correct.
SDO therefore issued a notice on 14/3/2024.
Correct.
Therefore, an 18/3/2024 hearing was done.
Yes.
34/2024 report was submitted.
Yes.
Then you suspend him. Suspend him, not?
No.
What do you do? What is the order of the 99?
99.
No. 99 is just to let him return the
Not been distributed to anyone.
misappropriated
Directed
rights.
To inform you to return the bag.
Yes.
So you put it on 99 to return the bag.
Yes.
So which he has challenged it.
Yes.
Because on the basis that the subdivisional officer has no jurisdiction.
Yes. Yes.
Okay.
Yes.
But I'm asking you, what have you done in pursuance to the order dated 30, report dated 34? Because what it seems, complaint, as I was repeating, 14/3, there's a complaint given.
Yes.
The DC assigns this to the SDO.
Yes.
SDO calls for a inquiry
Yes.
on 14/3. 18/3 inquiry done.
Yes.
34/2000 report submitted.
Yes.
Then what did you do?
Your Lordship, yes, it took some time to issue this impugn order, not out.
Which order?
9/9
This is being
2024.
done by the SDO. What did the DC do? Because the DC was made the complainant. The complaint. You see, Mr. Gandame.
Yes. No,
You see, the affidavit of yours does
Yes.
not inspire the confidence of this court for one reason.
Correct. Correct.
A complaint is made to the DC.
Correct. Correct.
DC says that, look, yeah, I'm not going to go there and then
Yes.
back.
Yes.
You say that DC says, look, here the ADC, you inquire it. ADC inquires and submits a report on 34.
Yes.
What did the DC do?
Lordship, yes. Your Lordship,
There's no report.
So, if the DC has not done anything,
yes.
and the order of interim order was passed on 410.
Yes.
410. So, therefore, the question is, what did the DC do?
Your Lordship, if you read the impugn order, the
Impugn order is for returning the bag.
yes, not only that, the SDO civil, the SDO civil in this impugn order has stated that I am directed to inform you. So the direction was given.
Where?
Your Lordship, towards the last para,
in this
regard, I am directed to inform you. Yes.
So therefore,
Yes.
who has directed? Where have you mentioned in your affidavit?
No. I have not mentioned that in my. Your Lordship, here my only submission is
So,
this, Your
so
Lordship.
produce that order.
Yes.
See, they cannot be on by telephone.
No. Yes.
Telephone also wouldn't do. So there has to be something.
Yes. Your Lordship.
Where is the direction?
Your Lordship, that I don't have it here with me, Your Lordship. But Your Lordship, my only submission is this, Your Lordship.
Tuesday we'll get that document where the direction is given to the SDO.
Yes. Yes.
And if there is no direction, that order is absolutely, because the fact, his submission therefore, his case as it appears, is that he's only the ADC.
Yes, as per the rule.
ADC.
Yes.
ADC's upper authority is the DC.
Yes.
Who has been empowered as per the rules?
As per the rules. The ADC only.
The ADC.
So therefore, the direction.
There has to be a direction by the ADC.
Correct.
So where is the direction of
Your Lordship,
if there is no direction, this order has to fail. But I also understand one thing, Mr. Andame, these are things which requires to be taken properly.
Lordship, that is why.
There is a misappropriation.
Yes.
You have. You see, it is only on the question of jurisdiction.
Correct.
An order has been passed. There is a stay operating on 410.
Correct.
It is impacting the distribution under the Food Safety Act.
Correct.
Food Security Act.
Yes.
Which is of vital importance.
Correct.
Keeping these matters pending is not in good place.
No.
So therefore the question is, he is only challenging on the question of jurisdiction.
Yes.
If we set aside this order and give you the liberty to do as per law.
Yes. Your Lordship, I agree.
Instead of unnecessarily defending a
Yes, yes, yes.
and keeping the matter pending
Correct.
has no sense.
Correct, correct.
So therefore, if we set aside this order, you are and giving you the liberty to take action if
Yes,
necessary,
yes.
then I think through the proper authority you can take action
Yes,
on the basis
yes.
of that report.
Yeah, Your Lordship, even in our affidavit, we are on that line only, Your Lordship. Because this impugn order, Your Lordship, is actually not punitive in nature. We are just asking the petitioner to.
What action you have taken on the report of 34? That is a very important thing.
Lordship, yes. However, Your Lordship, yes. As far as the rule says, it is the ADC who have the authority. Probably this impugn order that has been passed by the SDO civils is not as per the rules. That I agree.
So therefore, the person should pass an order.
Yes, yes.
So therefore, unnecessary keeping.
No, yes, yes, correct. I agree with my lord. I agree with my lord.
If it pleases your lordship, then your lordship may dispose and
Yes, yes.
to the state respondents.
Yes, yes. It can be disposal. I completely agree with my lord. I completely agree with my lord.
So that is what I said.
Yes, yes.
Unnecessary keeping this.
No, no. And somebody there who falls under the BPL is not getting the rise because of this. So I agree with my lord. I agree with my lord.
This is a very serious thing.
Yes, it can be disposed
But
of.
the fact remains that the SDO has done this.
Yes, yes.
Because the SDO could not have done it. Show me the provision why it cannot be done by the SDO.
I have enclosed the rules as well at page 23. Starting from page 23, the relevant part under chapter 3. Page 23. At page, that's the starting of the rules, and page 29.
Mr. Angami, I won't dispose of today. You know why? Yesterday, Mr. Takamasa said that if I remain here for 2 months, the cases will finish.
No, your lordship, this I am for disposal. This I am pressing for disposal.
Page 29, chapter 3. This is how the procedure has been laid down for the
Hearing
ADC to
before the district, the ADC headquarters have been designated as the district grievance redressal officer of his or her respective district for expenditures and effective redressal of grievances of the agreed person in matters relating to the distribution of enter. The district enumerating officer shall notify the days and time for receiving the complaints in the fee of so and so shall be paid. If he finds that the complaint carries any substance as may be, and relief as to will be no for compliance with him. If he finds the complaint does not have any substance, and relief that can be provided, direction for provision of entitlement not provided in direction process followed by inquiries. He will verify whether there is a prima facie substance in the complaint to proceed in the matter. If he is satisfied that there is a prima facie ground to proceed in the matter, he shall issue that notice to all the parties in the case about fixing the time and place the date fixed for their initial date of the. So here, as per Rule 11, it's a complete code. Rule 10, it's a complete code by itself.
Yes.
Isn't it?
Yes.
This is the rules, Nagaland Food Safety Rules 2016.
Yes.
It's a complete code by itself.
Yes.
So therefore, that particular complaint may have been sent to the DC, but the DC should not have been filed to the DC.
Yes, it should have been sent to the ADC.
So,
by the, yes.
so
That I agree.
therefore, we direct the DC to place that matter before the ADC.
Correct. Because your lordship here.
Because it is the ADC who has to come.
Who has the authority, your lordship. Correct, correct. Your lordship, it is also more important because for the fact that.
I'll make it as your submission.
Yes, because No,
Mr. Angami.
Lordship.
But this court also to tweak requires from an order passed by the order may prepare an affidavit before the commission within 30 days. Commission is the State Food Commission. Do you have a State Food Commission?
Lordship, as far as
Chairman
the
society, yes, it is there.
Yes.
Chalo.
One more submission, your lordship, because the allegation made actually is admitted.
No.
No, the thing is, I think it has to be admitted before an authority.
Yes.
Yes. That again I agree, your lordship.
heard Mr. Illegal Zealand Council appearing on behalf. This is subject to caveat. Both of you asked for this vote.
Yes, Your Lordship. It can be placed on record.
Heard Mr. Ali Delali Council appearing on behalf of the petitioner, Mr. Enangami Delali Council appearing on behalf of the respondents. The petitioner herein is aggrieved by the inquiry initiated by the respondent number 3 and as dated by a communication dated 14/3/2024 and the subsequent order dated 9/9/2024 passed by the respondent number 3. The issue involved in the instant proceedings lies within a very short compass. The issue is as to whether the respondent number 3, who is the subdivisional officer C, working in the establishment of the establishment of the Deputy Commissioner Waka Nagaland, has the jurisdiction to make inquiry in respect to grievances relating to distribution of food grains, and if not, full stop. This court duly takes note of that the government of Nagaland, on the basis of, in terms with subsection 1 of section 40 of the National Food Security Act 2013, had framed a set of rules in the name and style of the Nagaland Food Security Rules, Agato National Food Security Day Safety Rules Act 2013. In the name and style of the Nagaland Food Security Rules 2016. Chapter 3 of the said rules deals with Chapter 3 of the said rules, rules of 2016 for short, rules of 2016. Chapter 3 of the rules of 2016 is with the heading, inverted comma, grievance redressal system. A perusal of chapter 3 reveals a perusal of redressal system. Rule 10. Deals with hearing before the District Grievance Redressal Officer, for short, DGRO. The ADC headquarters, who is the respondent number 2 herein, isn't it?
Yes. Yes.
The ADC headquarters, respondent number 2 herein, headquarters, in terms with Rule 10A, have been designated by the rules of 2016 as the District Grievance Redressal Officer. in respect to matters relating to expeditious and effective redressal of grievances of aggrieved persons in matters relating to distribution of entitled food grains. The manner in which the district grievance redressal officer can accept complaints, receive complaints, and how inquiry it can be carried out by the DGRO has been specifically stipulated in subrule B E and F of Rule 10. Full stop. In the backdrop of the above, if this court duly takes note of the facts involved, and more particularly from what have been stated in the affidavit in opposition filed by the respondent numbers 1, 2, and 3, it reveals that a complaint was filed before the Deputy Commissioner Woka by various villagers alleging that what is AAY?
It's Lordship.
Antyodaya Anar Yojana.
The AAY allotment amounting to 580 bags from August 2021 to December 2023 have been misappropriated. And further, the transport subsidy from the Department of Food and Civil Supplies WOCA for amounting to rupees 79,000 have been also misappropriated. The Deputy Commissioner WOCA, on receipt of the said complaint, as stated in the affidavit in opposition, forwarded the same to the respondent number 3. And the respondent number 3, on the basis of the said, initiated an inquiry, as would be seen from the communication dated, notice dated, order dated 14/3/2024. And further, on 18/3/2024, the inquiry proceedings were held, and on 30/4/2024, a report was submitted. It is further seen that the respondent number 3 had passed the impugn order on 9/9/2024. However, it is very strange to take note of that when there is when there is already a grievance redressal system as mandated in the rules of 2016, and the ADC HQ have been designated as the District Grievance Redressal Officer, and the said rules duly mention as to who would receive the complaints and how the complaints would be adjudicated by the DGRO and what orders the DGRO is competent to pass. It cannot be passed, comma. The respondent number 3, as well as the Deputy Commissioner, Walker, could not have exercised the jurisdiction in view of Rule 10 of the rules of 2016. At this stage, this court, however, finds it very pertinent to take note of a submission made by the respondent counsel, made by Mr. N. Angami, the learned counsel appearing on behalf of the respondents, who submits that, who fairly submits that although as per Rule 10 of the rules of 2016, it is the ADC headquarters who have been conferred with the jurisdiction as the district grievance redressal officer. The complaint which was submitted, appropriate direction be passed by this court directing the Deputy Commissioner Woka to forward the complaint to the respondent number 2, complaint dated 24/1/2024, to the respondent number 2, so that appropriate action can be taken in terms with Rule 10 of the rules of 2016. Lord, the learned counsel further submits that as the allegations in the instant case relates to misappropriation of food grains, it's a very serious allegation, and as such, further directions be also issued to the respondent number 2 to initiate appropriate action within a time frame. Lordship. Footstool. In the opinion of this court, the Deputy Commissioner Walker, who have duly received the communication dated 24/1/2024, the representation dated 24/1/2024, ought to have guided those complainants to file the same before the ADC headquarters, inasmuch as it is deemed that the Deputy Commissioner Walker was aware of the rules of 2016. This court also takes note of the communication, the representation submitted on 24/1/2024, which relates to allegations of misappropriation. And as such allegations are required to be inquired into by the appropriate authority. However, any orders being passed by an authority which is not conferred with the jurisdiction cannot be allowed to exist. Accordingly, the instant petition stands disposed of with the following observations and directions. The inquiry so initiated by the respondent number 3 by the order dated 14/3/2024 is non-est, and accordingly the order dated 14/3/2024 as well as the inquiry held by the state official by the respondent number 3 is declared to be are interfered with. Number 2. The order dated 9/9/2024 by which The respondent number 3 passed an order having no jurisdiction. The same is interfered with. Number 3. This court directs the Deputy Commissioner, Walker, to ensure that the letter, the representation dated 24/1/2024, is forwarded to the respondent number 2, who is the ADC headquarters, and the DGRO. Full-stop. This court observes that the respondent number 2 thereupon shall take action as mandated in Rule 10 of the Rules of 2016 without being influenced by the observations made herein above. Anything more?
Deeply obliged.
I am deeply obliged.
One more.
Over. My colleague.
Okay.
Your Lordship, interim, if any, stands should stand.
Interim order so passed as vacated in.
Deeply obliged.